Director SGI, and all my colleagues. I've been given the responsibility of assisting your Lordship on account of your Lordship's ill health and to assist the Director in steering this program. So without wasting much time, I'd like to call upon the first presentation by Ms. Jamyang and Mr. Sashahang. Are you going to do it jointly or? Okay, thank you.
The topic, Sashahang and me will be presenting together because we have been assigned similar topic, same topic. So our topic for presentation is judgment writing on civil cases with citation of Honorable Supreme Court of India. So the outline of our presentation is how to begin, language and style of judgment, marshalling of facts and appreciation of evidence, issues drafting, application of law, appreciation of evidence and factual finding and analysis, logic of adequate reasoning, and recording of findings. So I will be dealing with how to begin, marshalling of facts and appreciation of evidence, application of law, appreciation of evidence and factual finding and analysis, and Mr. Sesham will be dealing with language and style of judgment, issues drafting, logic of reasoning, adequate reasoning, and recording of findings. So, judgment writing, as we all know, is an essential feature of judicial functioning performed by the judge. Now, art of judgment writing is not taught, but it is an acquired skill, and every judge has his own way of writing. So, I have given it in detail. I don't need to read it, I think. Each individual develops his own style, acquire skills to marshal facts and evidence, determine and apply legal provisions of facts, and then arrive at conclusion. So basically the object is to give a clear, lucid, unbiased and reasoned judgment with clear-cut finding. So the most important thing while I was going through the materials while presenting the judgment was, everywhere it is written that the judgment has to be reasoned. So reasoned judgment is the soul of the judgment. This is what was what I understood. And since we have been asked to deal with the writing of judgment in civil cases, so definition of judgment. As per section 2(9) of CPC, judgment means statement given by a judge on the ground of a decree or order. Order 22, Rule 4(2) of CPC provides, judgment shall contain a concise statement of case, the points for determination, the decision thereon, and the reasons for such decision. Now in Balraj Taneja and another versus Sunil Madan and another, 1998, 8 SCC 396, para 42, Honorable Supreme Court has observed that judgment should be self-contained document from which it should appear as to what were the facts of the case and what was the controversy which was tried to be settled by the court and in what manner. The process of reasoning by which the court came to the ultimate conclusion and decreed the suit should be reflected clearly in the judgment. So from this what we understand is that the judgment has to be self-contained. It has to set out the facts, the nature of the case, why, what, the nature of the case for which we are writing the judgment, the facts of the case, then the issues in dispute between the parties, and then how by applying the facts and the evidence, the issues were determined, and finally what the conclusion was arrived at. So basically, what we understand from this is that a judgment requires introduction, then the middle portion and the end. So ingredients of judgment basically is introduction, how you introduce, and then setting out of the facts, then the issues, then how you determine the issues by applying the laws and the facts, and then the end, the finality of the decision as per what you have analyzed and what reason you have given. So in Joint Commission of Income Tax Surat versus Sahili Leasing and Industrial Limited, 2010, 6 SCC 384, Honorable Supreme Court of India has laid down the guidelines for writing judgment. It has, the Supreme Court has specifically stated that the guidelines is not it is just an illustrative guidelines, illustrative in nature and not exhaustive. So I'll just read it out. I did not write it in the PowerPoint because, to be very honest, I don't know how to make PowerPoint also. So then it was very difficult for me to put it. So I've just given you the citation. I'll read it out how it is to be done. So then in para 7 it is said that the guidelines are only illustrative in nature, not exhaustive, and can further be elaborated looking to the needs and the requirement of a given case. So what it says is that it should always be kept in mind that nothing should be written in judgment or order which is not germane to the facts of the case. It should have a correlation with the applicable law and the facts. The ratio decidency should be clearly spelled out from the judgment and the order. Second, what it says is that after preparing the draft, it is necessary to go through the same to find out if anything has escaped, any important points have escaped, and what you need to write. So basically, just revise the judgment and see what you have missed out. And then, thirdly, it says that the ultimate finished judgment order should have sustained chronology, regard being had to the concept that it is readable, continued interest, and one does not feel like parting or leaving in midway. To elaborate, it should have a flow and perfect sequence of events which would continue to generate interest in the reader. Like I said, it has to have proper introduction, then you set out the facts, what is there, then the dispute. So it has to be in a perfect sequence so that the reader also understands what the judgment is actually trying to say. Then after that, appropriate care should be taken not to load it with all legal knowledge on the subject, that the citation of too many judgments creates more confusion rather than clarity. Just because you know, that doesn't mean that you put each and everything what is required, that is to be added. So it says that the foremost requirement is that leading judgments should be mentioned and the evolution that has taken place ever since the same were pronounced and thereafter latest judgment in which all previous judgment has been considered should be mentioned. While writing judgment, psychology of the reader has also to be borne in mind, for the perception on that score is imperative. Then it said that the language should not be rhetoric, should not reflect a contrived effort on the part of the author. Then after arguments are conducted, an endeavor should be made to pronounce the judgment at the earliest and in any case not beyond a period of 3 months, keeping it pending for a long time sends a wrong signal to the litigant and the society. Then lastly it says that nothing should be reflected in the same in the judgment which may hurt the feelings and the emotion of the individual and society. So this guidelines is, like I said, is just illustrative, not exhaustive, and one can elaborate depending to the given cases what is there. After that, now from here we understood what is required in the judgment. It has to be lucid, it has to be reasoned, and then the guidelines also which you have read, and then why it has to be reasoned, why it has to be clear, why the introduction is required, why the sequence has to be given is, now I'm just going to talk about that. Why you need it, because the judgment has to be understood. By whom it has to be understood? By the parties and the council. Because others probably may read it, some who has interest in it, otherwise everybody is not going to read it. So the judgment has to be reasoned, it has to be understood by the parties and the council, the authorities who are required to comply with it or implement it, the members of the bar and the public who may like it, who may rely on it, where it has a precedential value, and the appellate or the revisional court which has to find whether it is right or wrong. So because of this, the judgment has to be reasoned. Now, how to begin with the judgment? Now the process of judgment, it begins before the end of the case. So what is required is that we need to, the person who is writing the judgment, the judge, requires to study all the documents, pleadings, statements and issues, then the arguments put forth by the counsel and the notes which the judge has made while hearing the case during the pendency, during the proceeding of the trial, so that the judge has a clear understanding of the case. Because it says that the clear thinking is very essential while writing a judgment, to give a clear picture of what the conclusion, what the finding is. So because of that, before beginning with the judgment, what is more important is to understand the case in hand, and then you tackle with the issues. Then how to begin? Now, Judgment at the top, everybody knows that the name of the court has to be there. Then the title of the case, number of the case, no, the title and number of the case, title suit, money suit, title of the case, and then the designation of the judge and the date of the judgment when it is to, when the judgment is delivered, and the name of the parties, since I'm dealing with civil judgment, so plaintiff and the defendant, and then the counsel representing the parties. So, counsel representing the parties, then judgment should be, it should bring clarity. So nature of the judgment has to be set out. So usually what I do, what I have learned is that this judgment will decide on this is the case of plaintiff for recovery of suit type money or for declaration. But while reading through the articles and all, what I came to know is that Lord Denning has said it has to be interesting. It should not be conventional like this judgment will decide on this. But however, I have always given it in a conventional way, so probably the seniors will explain me how to make it interesting at the beginning. So I was not able to, I have not been able to do it so far. So then, after that, the case of the plaintiff has to be set out briefly. Not each and everything what is written in the plaint has to be typed verbatim what is there in the plaint. Only you need to understand the case and then you can set it out briefly. And similarly, the narration of the defendant's case also has to be set out. And in doing so, what will happen is that the judge will also have a fair understanding of what the plaint is. So usually what I do is that whenever I write judgment, it might take time, but then I write everything myself only, because with that it helps me to understand the case. So even if it is a long judgment or whatever, I read the plaint, I try to write it myself only. Because if I don't write it, if I let the steno write it, then I don't understand the case only. So reading and writing, what I have experienced is that when you write it, you get a more clearer picture. So this is what I do. And then in doing so, should be noticed that it should not, you should not repeat the same thing again and again. So this is how the beginning of the judgment, as per my understanding, is. And Mr. Seshan will deal with the language, the second part. Because we...
Mr. Justice Bhaskar Pradhan, Hon'ble Judge High Court of Sikkim, learned District and Session Judges, learned Chief Judicial Magistrate, learned Director, Sikkim Judicial Academy, Assistant Director, learned Judicial Magistrate. Good morning, everyone. The previous speaker has given a brief introduction about as to what is judgment, how to begin with judgment. So I'll be directly deal with the topic, language and style of writing judgment. So as we write judgment, we decide a cause. So the intended reader of our judgment would be first the parties who are involved. Firstly, the counsels who are representing parties. Secondly, the parties involved. Thirdly, and importantly, the appellate courts will be hearing in case of appeal. And others may include law students and many others. So here comes the importance of language and style of writing judgment, because we are writing not for persons who have a legal knowledge and understanding of language of law, but also those persons who are laymen, so to say. So first, I have basically found some of cases wherein the apex court or the constitutional court has said as to what should be a style of writing judgments. So first, the Supreme Court in 2010 6 SEC 384 has said that language should not be rhetoric. In 2023 7 SEC 282, Supreme Court has quoted Justice M.M. Corbett, former Chief Justice of South Africa, that, and I quote, lucidity. Lucidity is one of the qualities that a judgment should have. and a construction of language and sentence should be simple. Preferably a short sentences must be used. Maintain a simple, straightforward flow to the narrative and avoid repetition of words and phrases, and normal rules of grammar be used. In the same judgment, it also says in paragraph 21 that, especially when our judgment is little long, so table of contents be drawn so that it assists access to the reader. In the next case, 2023 SCC Online SC 413, at paragraph 56, it says that it is desirable that all the courts and the tribunals, as a matter of practice, number paragraphs in all orders and judgment in seriatim, so that it becomes it comes to a ready reference, especially for the appellate courts and the readers to refer. And in 2021 SCC Online SC 672, it has said that judgment should be coherent, it should be systematic and logically organized. This is with regard to a language and style of writing judgment. So next subtopic I have is issues, framing of issues. Slide 7. So the day of framing of issues is also called as the first day of hearing. It is the day on which the issues are discussed and settled, and is also referred to as the first day of hearing. Framing of issues is to settle upon the actual dispute involved between the parties. Hon'ble Apex Court in 2009 17 SCC 796 has outlined as to what is the object of framing of issues. It has said that, number one, it is to focus upon the questions on which evidence is to be laid by the respective parties. So we are confining the case. Number two is to indicate the party on whom the burden of proof lies, to adduce evidence and to prove the respective case. The Himachal Pradesh High Court in 1993 SCC Online HP 13 has said that while framing issues, the facts alleged by one party and denied or not admitted by the other party are to be identified and considered, and not other facts. So this involves the consideration must be confined to only material facts, those facts which are actually an issue. So next, Apex Court in 2011 8 SCC 249 has said that it has emphasized that it is the bounden duty of a court to take due care, caution, diligence and attention while or at the stage of framing of issues, because it is such an important stage, like it can be referred to as the foundation of a case. The party will, while leading evidence by the respective parties, they lead on the basis of issues framed. Next subtopic is reasoning in a judgment. Reason is the soul and spirit of judgment, says so Justice Sabyasachi Mukherjee, former HCGI. Reason is the basis for the conclusion of our judgment. It is the reason of a judgment that is commonly termed as the ratio decidendi, which in Latin terms means the reason or the rationale for the decision. And it is the reason or the ratio decidendi that forms the precedent. Hon'ble Supreme Court in 2021 SCC Online SC 672 has said that all conclusions of a judgment should be supported by reasons duly recorded. Hon'ble Supreme Court in 2010, 9 SCC 496, at paragraph 17 has highlighted the importance of giving reasons while passing a judgment or order by any judicial or quasi-judicial body, which consists of 15 points in total. So I'll be just highlighting only the important points. Point number 3, it says that insistence on recording of reasons is meant to serve the wider principle of justice, that justice must not only be done but it also appear to be done as well. Point number D, recording of reasons also operates as a valid restraint on any possible arbitrary exercise of judicial and quasi-judicial or even administrative power. Point E, reasons reassure that discretion that has been exercised by the decision maker on relevant grounds and by disregarding extraneous considerations. Point G, reasons facilitate the process of judicial review by superior courts. Point J, insistence on reason is a requirement for both judicial accountability as well as transparency. Point L, reasons in support of decisions must be cogent, clear and succinct. A pretense of reasons or rubber stamp reason is not to be equated with a valid decision-making process. And last point number O, in all common law jurisdictions, judgment play a vital role in setting of precedents for the future. Therefore, for development of law, requirements of giving reasons for the decision is of the essence and is virtually a part of due process. To close this subtopic, I would like to quote former Chief Justice of India, Justice Sachin Mukherjee. Lordship emphasizing on the importance of reasoning in the judgment as said, and I quote, "The supreme requirement of a good judgment is reason. Judgment is of value on the strength of its reason. The weight of a judgment, its binding character or its persuasive character depends upon the presentation and articulation of reasons. Reason, therefore, is the soul and spirit of a good judgment." So now for covering this topic, I would like to request.
Councillor has talked about the language of the judgment and the reasoning. So like I have also said, and he has also emphasized on the point that the reason is the most important part in the judgment. So Order 20, Rule 5 states that court to state its decision on each issues. In suits in which issues have been framed, the court shall state its finding or decision with the reasons. Therefore, upon each separate issues, unless the finding upon any one or more of the issue is sufficient for the decision of the suit. So, for reason also, like I said, that in the judgment there has to be introduction, there has to be brief narration of the facts of both the parties, and then the issue in controversy, the dispute has to be set out, it has to be framed, and then the issue is determined, and then finally the reason is arrived at. But for coming to a reasoning, what is most essential is, even for determining of the issues and for coming to a reasoning, what is most essential is the marshalling of facts and appreciation of evidence. Now, marshalling and facts and appreciation of evidence, it is basically the backbone of the judgment. The quality of judgment also ultimately depends upon the proper marshalling of facts and appreciation of evidence. Now, marshalling, the expression marshalling of facts, appreciation of evidence is not defined either in Indian Evidence Act or in the CPC or in CRPC. So, marshalling basically means arranging of evidence. Now, while giving the introduction only, the facts is already marshaled. We have already stated what the plaintiff is there, what the plaintiff says, what the defendant has stated. Now, for determining the points also, we need to marshal the facts and the evidence as per the issues in controversy, because we are not going to take up all the issues together. Sometimes when the issues are related, we take it up together. Otherwise, we take the issues separately. So depending on what the issue is there, we need to marshal the facts and evidence and then deal with the issue in hand. So marshalling basically means arranging of the evidence, sequencing of evidence, skills of picking up various pieces of evidence on a particular disputed point and then putting it together. So appreciation means assessing the worth and the value and the quality of the particular piece of evidence. And whether you write a civil judgment or a criminal judgment, whether you write a civil or a criminal judgment, Indian Evidence Act, you need to know Indian Evidence Act. Because while writing a civil or a criminal judgment, what is required when you appreciate the evidence is the Indian Evidence Act. No separate scheme is provided in the Indian Evidence Act for for civil or criminal cases. Best judge in R versus Burdett 1824B commented that there is no difference between the rules of evidence in civil and in criminal cases. If the rules of evidence prescribe best course to get at the truth, they must be and are the same in all cases and in all civilized countries. A civil case can be proved by applying the yardstick of preponderance of probabilities, where in criminal case it is beyond reasonable doubt. So, now, how the marshalling is done? So first of all, what we need to do is examine all the evidence, whether oral or documentary, that is in hand, which is produced by the parties, and then arrange all the connected evidence together under the analysis of an issue or a point of determination. So you, like I said, while you're tackling with a particular issue, you need to collect all the evidence, then put it on sequence as per the issues which you are deciding. Then, while going through this, what I came to learn is that another important point while marshalling the Another important point while marshalling of facts and appreciation of evidence is that no specific qualification is required for being a witness. So what you need to understand is that what we need to see is that Section 118 of Evidence Act says who may testify. So a witness who can understand the question put to him and who can process the faculty to give a rational answer can testify. Secondly, one who is acquainted with the facts and circumstances of the case, that witness will testify before the court. Then another is no particular number of witnesses is also required to prove a particular issue or a proof of fact. So Section 134 of Indian Evidence Act, it says that the basic rule of evidence, no particular number of witnesses shall in any case be necessary to prove of a fact. It is in Maksudan and another versus State of UP. It says that it is the duty of the judge to record a finding on a disputed point by weighing evidence and not by counting the number of the witnesses, because it is the quality and not the quantity of evidence that matters. Another is also with regards to the demeanor of the witness. So this demeanor, while sitting as a judge, you can see the demeanor of the witness, also how the witness is answering to the question put to the witness, whether the witness was nervous or whether the witness was lying, and all this is something which the judge needs to acquire. That nobody can teach, I think, that this person is lying, you need to do this. This is the demeanor of a witness when a witness is lying, and all that is something which a judge needs to acquire in the course of time. And then another one which I have seen is also the eminence, I think, of the witness, which you need to see whether the person who is the witness who is deposing before the court against the person, against the opposite party, is whether he has some enmity with that person or whether there is any kind of problem with that person because of which he is deposing before the court. So basically, while marshalling of facts and appreciation of the evidence, you need to see all these things also about the witnesses, the demeanor of the witness, then the eminence also. Then another thing is that whether the witness has how many the quality of the witness is important, not the quantity of the witness. So these are all the basic things which while marshalling of facts and evidence, one needs to understand. So thank you very much.
Topic to cover, that is recording of findings. The findings of a judgment is ultimately the fruit of a judgment. The conclusion of a judgment, it may be its finding on a fact, on point of law, or on a point of fact. Order 14 Rule 2 of CPC says that court to pronounce judgment on all issues. Judgment must deal with all issues and record its finding on each issue. Supreme Court in 2014 9 SCC 212 has said that it may be a finding of fact or a finding of law or even be a finding of mixed question of fact in law. It is only when the conclusion is supported by reasons on which it is based that one can logically describe the process as tantamount to recording of finding. In 2022 2 SCC Civil 33, the Apex Court has said that under Order 41 Rule 31 CPC, even the judgment of the appellate court must reflect conscious application of mind and must record the court's finding supported by sufficient reasons. With this, I would like to conclude our presentation on judgment writing in civil cases. Thank you.
Thank you. Everybody hone their skills in writing judgments, civil in nature. Now I call upon the next team to kindly give their presentation.
Good morning to Honorable Lordship Mr. Bhaskar Pradhan, Judge, High Court of Sikkim. Good morning to all my seniors present here and Sesian sir and Mahima madam. With the permission of His Lordship, I would like to start my presentation. The topic that was given to us today to Ms. Mahima and me is the judgment writing in criminal cases. So I will be dealing with how to begin with the judgment, language and the style of the judgment, and marshalling of facts and appreciating the evidence. And Mahima madam will be dealing with charge drafting, application of law and appreciation of evidence, and logic of adequate reasoning. Now, as we all say that judgment writing is an art, it's an art that is acquired by the judges after gaining experience in their career. But since ironically being the junior most judge, since I'm presenting how to write a judgment, I have incorporated whatever I have learned from my learned seniors in 1 year of my training and 9 months of me sitting as a judge. So with my limited knowledge, I would say what is judgment at the cost of repetition, as my senior and Sesian sir has already repeated. So judgment is basically defined as the reasoned order or the pronouncement that a judge will be delivering on the issues that is presented before, that is the issue that is there before them. Now, while writing a judgment, what is very important for us to remember is what is the purpose of us writing the judgment? Why is it important? And the fact that us giving a one judgment might have a huge impact, and in fact it will have a huge impact on the other party who is at the receiving end. Hence, before writing the judgment, it is very important for us to know what is the purpose of writing the judgment. So I'll move on to the purpose first, and of course that the purpose of writing a judgment means to give our decision. We give our decision by delivering the judgment. Secondly, we explain the reason for our decision, why and what are the reason on the basis of which we have come to the certain conclusion, and that is how we communicate the reason to our judgment. And lastly, to provide a reason for the appellate court to consider our judgment. So this is the purpose of writing a judgment. Now the Honorable Supreme Court in the case of Joint Commissioner of Income Tax Surat versus Saheli Leasing and Industrial Limited I guess again this is a repetitive judgment, but it would be repeated in future as well. But in this case, what I got is the Supreme Court has dealt on how to write a judgment, but I haven't mentioned all the points that has been mentioned there that was given in the judgment. That is because it was a lengthy one, but I have incorporated those points in my PPT later. Now, how to begin? How to begin writing a judgment? Before even sitting with our laptops and the case file, I guess we already consciously and even subconsciously, we have already, a lot of time we've already decided on how to write or what judgments are we going to quote or what will be the decision or the outcome. So firstly, there's no two ways about it, reading the case file from cover to cover and mastering the facts. That is how we begin with. Secondly, listening in the courtroom. I guess listening to what the advocates are presenting before the courtroom and the case laws that have been presented by them, that helps a lot while we sit in writing a judgment. So secondly, listening in the courtroom is the key. Thirdly, making notes, flow charts and family trees. This, rather than criminal cases, this helps me a lot in the civil cases because they come and say this person is related to me from my mother's side and then the property devolved to the XYZ person like this. So when we are writing it, it becomes very lengthy, but when we make a family tree of it, it becomes very clear for us to understand the facts and how the property have been devolved in the civil cases mostly. And fourthly, drafting the outline. Of course, when we sit for writing the judgment, we do not delve into the judgment altogether. We make a framework, and drafting an outline becomes very important so that it will give us a chance to later to correct if there is any important information that we have missed out. We can incorporate it in later, so hence drafting the outline. And lastly, of course, before proceeding to draft a judgment, we should be clear about the facts, the law that we will be applicable, the law that are applicable, and the outcome of the decision. So now that we've prepared in our mind and the framework has been created, we would begin writing a judgment. Now, the starting of the judgment, how do we begin? We begin with who did what to whom. This is the basic, the key to writing the judgment. When we start, we say that this person has committed this crime and against this person. So who did what to whom? Secondly, what is to be decided? And thirdly, and the most important, we should omit all the details that are not required for writing, that are not required to decide the issue before us. Secondly, when we start writing the facts, the starting of our judgment should give the point of view of the facts, and that facts should lead us to the dispute in the cases. So the clear recital of facts and the cause of action and the manner that the case has been brought before us is to be mentioned in the criminal cases. For example, if the police has filed a charge sheet or the complaint has been filed before us, or if we have taken the suo motu action, that is to be mentioned in the beginning of the judgment, so that the person reading the judgment would know that how the case has been initiated before us. And the most important thing while starting a judgment is that we should try and avoid all the legal jargons and legal maxims, because when the person, a layman who is at the receiving end, is reading a judgment, they should at least they should have a clear idea of the facts of the case before us. Now the language and the style of judgment. The third and the second topic is the language and the style of judgment. Now the language and the style of judgment varies from individual judges to judges, and I think that we should keep it that way, because the language that we are comfortable in and the style of our comfort should be adopted while writing a judgment, because of course we can learn by looking at the judgment that is written by our seniors or the judges of the High Court, Honorable High Court and Honorable Supreme Court, but we cannot totally adopt and try to adopt everything that the style that they are doing it. So I think the best way to stick is the language and the style that we are comfortable in. And in this, I think following the judicial trinity is important. First thing, brevity, simplicity, and clarity. Be very brief. And I think brevity is an art that is not mastered by everybody. And if the person who can write in brief is the person who has a thorough knowledge about the facts. Only if you have the thorough knowledge about the facts will be able to write it in brief. Second is simplicity. Keep it simple. That is the simple formulae of writing the judgment. We should keep it simple. So that also, but keeping it simple, I feel there will be a less probability that we would commit a mistake. So hence we should keep it simple, and clarity. Our judgment must be clear so as to make the other person understand the reason and why the judgment has been given and for what reason. It should be mentioned very clearly. Hence, the language must be simple yet elegant. Now this, inside the topic of the language, I found an interesting example. The judgment one is written by Honorable Justice V.R. Krishna Iyer, of course the legal luminary in himself, but he's written, "The moderation is a fatal thing. Nothing succeeds like excess," wrote Oscar Wilde. Going for the literary lampoon, not for the forensic Paris. And yet the elation of elevation to the higher bench seduces some rogue brethren to imitate Simian fashion, the Oscar dictum and in excess. Process intemperately indulge in pejorative denunciation of the brethren of lower judiciary and thereby caricature the judicature. Now when I read this line, I think it took me 5-6 times firstly to read, then I opened the dictionary to understand few of the words, and on the other hand, there is a judgment that is written by Justice K.T. Thomas. Judges of higher court must, therefore, exercise greater restraint and adopt a greater care when they are tempted to employ strong terms against the lower judiciary. Basically, both of these judgments are talking about judicial restraint and how the higher court should be a bit restricted while commenting on the judgment of the lower judiciary. But while reading the V.R. Krishna Iyer judgment, and if the judgment is full of all this bombarding word, I feel we will need a dictionary by the side, and we will never reach the end of the judgment. So this is one of the very good example of how to keep it simple. Now, the marshalling of facts and appreciating. Now, every fact has a story to tell, and that story we should, and like the writer of a fiction book, we judges cannot take the liberty with the facts. We have to write the facts that is provided to us by the prosecution when the charge sheet is submitted by the police. Hence, but when we write the fact, of course, it is not necessary for us to stick by everything that the police officer has provided in the charge sheet, because they tend to incorporate anything and everything that they have done during the process of investigation. Now, in one charge sheet, the police has mentioned that the place of occurrence was to the northeastern side of the police station, and it was 8 to 10 kilometers from the police station. Now, I feel now, until and unless the time is the crucial factor in this case, we can avoid such details in the case. Hence, every writing of facts and writing it clearly is very important. In the facts, we must tell who the parties are, what the crime has been committed, and how the crime was committed. Now, when we write the fact, this fact should give us the clear view of what has happened, how has happened, who has committed the crime and against whom. So as to understand when the accused is before us, even why that person is before us and for what crime the person is standing before us, even he should get a clear view of the facts. Now, the golden rule of writing the fact is the relevant. The cram rule, that is the relevant, admissible and material facts must be written chronologically. And so that while the person who is reading the judgment chronologically understands what the case and how the case was, what the offense and what kind of offense was committed. The next topic hereforth will be dealt by Ms. Mahima. Thank you all for the patience hearing. Thank you, Lordship.
Narrator. Good morning, Honorable Justice Bhaskar Pradhan, Judge High Court of Sikkim, learned district and session judges of all districts, learned chief judicial magistrates and judicial magistrates present here today. I'll be taking up the topics: charge drafting, application of law, appreciation of evidence, factual finding and analysis, logic of adequate reasoning. starting with charge drafting. Framing of charge or charge drafting in a criminal trial is very important. The judge is to be mindful of the fact that the accused is entitled to be informed about the acts he is alleged to have committed and under what sections of the Indian Penal Code or under any other law. The charge frame should be precise, clear and complete, and the use of expressions such as etc. should be avoided. The particulars to be included in the charge frame is given under sections 211 to 213 of the Code of Criminal Procedure. The judgment should state the charges immediately after the narration of facts. One of the primary considerations while at the time of framing of charge is the test of existence of a prima facie case. The Honorable Supreme Court in State of MP versus Mohanlal Soni 2006 SCC 338 held that the nature of evaluation to be made by the court at the stage of framing of the charge is to test the existence of a prima facie case. It is also held at the stage of framing of charge, the court has to form a presumptive opinion to the existence of the factual ingredients constituting the offence alleged, and it is not expected to go deep into the probative value of the material on record and to check whether the material on record would certainly lead to conviction at the conclusion of trial. This was also reiterated recently by the Honorable Supreme Court in State of Gujarat versus Dilip Singh Kishore Singh Rao, Criminal Appeal of 2023. Moving on to application of law, appreciation of evidence, factual finding and analysis. The judge has to apply the law as it is. The judge is to conform to the law and not stretch the law. Precedents and binding authorities are entitled to respect. Appreciation of evidence. In criminal cases, evidence for each of the charges should be taken up and analyzed separately. The judge has to consider the entire evidence on the record on any one point and then come to a finding thereon. It would not be sufficient to state that on a careful consideration of the evidence, the court has come to this or that conclusion. There are three things that must be kept in mind while appreciating evidence. Number one, the volume of the evidence. Number two, the weight of the evidence. And number three, the probability of the evidence. It is this cumulative effect of all the three aspects of the evidence that finally determines a certain point, though the extent of which each one of them may influence the decision would be materially different. In criminal cases, the charge has to be established by the prosecution beyond a reasonable doubt, and if the evidence produced by the prosecution is either shaky or unreliable, the accused is and will be entitled to have a finding of acquittal in his favor, irrespective of the worth of his own case. This was held in Abdul Aziz versus Emperor 1916. It is sometimes possible in criminal cases to consider the entire evidence under different heads: direct, circumstantial, technical, formal. For example, in discussing the evidence relating to any particular incident, the judge may deal with the direct evidence that has been led in the case and then refer to the circumstantial evidence, which goes to either strengthen the conclusion drawn from direct evidence or the weaknesses thereof. The judge is also to be mindful that while the evidence as a whole is to be considered and weighed, the entire judgment cannot be a resume of the entire evidence. It should contain sufficient evidence to ascertain the facts deposed to and the importance of and the value to be attached to the evidence to it. However, it is also undesirable merely to give a summary of the evidence of the witnesses. A careful analysis and appraisement of the evidence is essential. The Honorable Supreme Court in Aftab Ahmed Khan versus State of Hyderabad 1954 has pointed out that it is necessary for a judge to give a summary of the evidence of material witnesses and to appraise the evidence with a view to be arriving at the conclusion whether the testimony of the witnesses should be believed, and that it was not commendable to make copious quotations verbatim from the evidence of the witnesses without full and detailed comments thereon. It is also important to discuss the evidence of the defense if they have been examined. A conviction, however, cannot be based on discussion of the defense evidence alone. The judge will have to discuss the prosecution evidence as well and come to a positive findings on the points sought to be made out. Absence of reasons in the judgment would vitiate the trial. All the decisions should be based on evidence and not mere speculation of theories of probabilities. It is to be clearly borne in mind that it is for the prosecution to prove their case, and an accused is not to be merely convicted because he offers an improbable explanation. And the last topic is logic of adequate reasoning. In criminal cases, as in civil cases, reasons must be recorded for findings. The absence of reasons renders the conviction invalid and the judgment vulnerable to invalidation. Reasons should be recorded with clarity, precision, to enable the appellate court to judge the sufficiency of the material before the trial court to support a conviction. Object of reasoning. The main functions of a reasoned judgment, as has already been said by Mr. Seshe, is number 1, to inform the parties the reasons for the decision. Number 2, to demonstrate fairness and correctness of the decision. Number 3, to exclude arbitrariness and bias. Number 4, to ensure that justice is not only done but also seen to be done. And number 5, to facilitate the higher forms of appeal to appreciate or examine the issues involved in any case more appropriately. The Supreme Court in State of Orissa versus Dhaniram Luhar has held that the hallmark of a judgment, order, and exercise of judicial power by a judicial forum is to disclose the reasons for its decision, and giving of reasons has been always insisted upon as one of the fundamentals of sound administration, justice delivery system, to make known that there had been proper and due application of mind to the issue before the court, and also as an essential requisite of principles of natural justice. In Uttar Pradesh State Transport Corporation versus Jagdish Prasad, 2009, the Honorable Supreme Court has observed the giving of reasons for a decision is an essential attribute of judicial and judicious disposal of a matter before court, and which is the only indication to know about the manner and quality of exercise undertaken, as also the fact that the court concerned had really applied its mind. Thus, in writing a good judgment, the judge has to take all the material facts, alleged or brought out in evidence, into consideration, analyze the entire materials before him or her in proper perspective, giving due allowance to human feelings, constantly keeping in view the onus for the proof of different disputed facts, try to understand the motive which may have impelled the accused to take such and such actions, or the witnesses to depose either in support or against, and then apply the law to the proved facts of the case. What Rudyard Kipling has said is very relevant here. I keep 6 honest serving men. They have taught me all I know. Their names are what, where, when, how, why, and who. Thank you.
Thank you, team Ms. Mahima and Ms. Naritya. Now we've come to the conclusion of the first session, and the house is open for interaction. Would anybody like to put any questions? The mic is here. Anybody? Anyone? Lordship, some comments on the session, please.
The takeaway, I think Sikkim is in sound hands. They are good judges. If this presentation was a work of labor and hard work, and I'm sure each of you, while rendering your judgment, will put in the same kind of effort and have been doing that. And therefore, I don't think Sikkim should worry much about justice being done. So, bravo to all of you. Good presentation. I think very well done. One thing that struck me in these sessions was what Ms. Jamil pointed out about not understanding the making of PowerPoint presentation. I have noticed that all of you have used the PowerPoint presentation, but somehow it was not working. I could see multiple plates, but it was not being reflected on the screen. Was it a problem with the Judicial Academy or the session takers could not handle the PowerPoint presentation?
Lordship, I think no, we didn't have a problem here. Maybe there was some problem in the network with your Lordship's.
So it was going one by one.
Yes, Lordship, here we didn't have a problem. The presentation was
Okay,
fine.
so it was okay.
It must have been a technical hitch on.
Okay, so it didn't come through to me. That's fine then. What Ms. Naivitya Sharma pointed out about the judgment of Justice Krishna Iyer, that was quite a bold point of view, isn't it? And I'm glad she made that statement because if you have got the compilation which I have handed over about writing judgments which are authored by various, men of legal prominence, you will find very diverse views about writing judgments. Some talk to you about being very precise, use simple language, and some of them use sometimes a language so difficult for even you and I, after years of training, to understand. I was just recently, reading in a view by Justice Surikant. He rendered an opinion in, I think, the Punjab and Haryana High Court, in which he advocated writing judgments as if it is a work of fiction, literature, make it interesting for the reader. In that compilation, you will also find a writing by Dr. Balaram. He was the erstwhile director of the Chandigarh Judicial Academy. Although he was never a judge, but he's a man of great legal learning. And he advocated the Denning style of writing. What I gather from reading all these articles and getting experience from the more experienced of our judges is that each one of us, like all of you rightly said, must develop our own style of writing judgment. What should never fail us is our understanding of the facts and the law. That is the paramount importance. Now, what we understand by what is fact and what is law is again of great relevance. Facts come to you in all kind of manner. Facts are never narrated to you the way you desire it to be. You have legal training, so each of you will expect a certain set of facts coming in a particular manner. But then those people who are presenting these facts, maybe they did not know how to present it. Maybe, the lawyers did not know how to draft it properly. So it will not be exactly the way you want it. Now, how do we then churn out the facts? And that is where the expertise comes in. That is where our training comes in. First thing, as I understand, is, and I'm sure the senior judges will also agree with me, we need to have a lot of patience. Without patience in reading our briefs, without patience in going through every detail of the documents that are presented to you, and put it in a particular order, it may be very difficult to understand the facts and marshal it correctly. It is only when you understand these facts the way it should be will you get the right answers. The truth lies there. So we need to take a little time in understanding the facts. In fact, my view is spend at least 60 to 70% of your time trying to unearth the facts. That will give you a complete mastery over the case. Then apply the law. I think it is very, very important that we do that. Another thing which I wanted to discuss with you is, we concentrate a lot on writing judgments, but I think, at every step of the trial, you are applying your mind in the facts of the case. Each of them will entail a great amount of understanding the stage and the requirement of applying the law at that stage. Like all of you pointed out, in criminal cases, at the stage of framing of charge, it is prima facie case, and at the stage of judgment writing, it is something completely different. We all know that, isn't it? Similarly, in civil cases, issues, I think much of the battle would be won if we understood how and why we should frame issues correctly. What are issues? How do we understand these issues? If you read the letter of the law, then it may confuse us. Because if there is a dispute between at a particular point, then there is an issue. So if one says something, the other says something and denies it, it is an issue. Right? But would that be an issue germane to the case? Is also a question which should bother us. What is the law and what is the requirement? In a case of eviction, in Sikkim at least, in both the 49 notification and the Gangtok Rent Act, there are precisely only 3 or 4 grounds of eviction. But in a petition, in a plaint, multiple grounds are taken, which is denied by the other side. Would it be correct to go into those issues is a question I wanted to throw open to all of you. What are your views on this?
I think only those grounds which are available under the law has to be it has to confine only on those grounds.
No, but the question I'm putting to you is, when you are framing an issue as per law, the CPC says that you frame an issue which, on a point which is asserted by one and denied by the other.
Yes, sir.
So in a plain there are multiple issues that they have raised, and it has been denied by the other side in their written statement. So why should the court not frame issues with regard to those multiple points?
Lordship, if we confine the case, even there may be multiple facts alleged and disputed, but ultimately it is only those limited grounds which are available.
No, but you are not giving me the answer at all. the question to you is, if you find a plaint in which multiple issues have been raised, he did not do this, he did not do that, he did not go here, he did not do that, and in the written statement, everything has been denied. Yes, I did it, I did not do that, I did this. So everything is a denial, right? Now, if you look at your CPC and the provision for framing of issues, you will find that a fact asserted by one and denied by the other is an issue.
Yes, sir.
So why shouldn't the court frame an issue? And once the court frames an issue, why shouldn't the court render its opinion on that issue for which you framed the issues? I want the application of mine by the other ones.
I think we need to look into the prayer portion, what has been sought for. And then
Okay.
frame the issues
Yeah,
accordingly.
okay. So therefore,
Therefore.
if you look at the prayer, then what happens?
Then I think the issues will become more confined to what Mr. Seshi was saying. And we can really look into the crux of the case altogether, instead of looking at everything that has been denied and disputed in the written statement and the plaint.
Okay, anybody else will throw us more light on this? CPC and guidance.
Latif, order 14.
Order 14.
Yes, Latif.
Let's look at order 14.
Settlement of issues and determination of suit on issues of law or on issues agreed upon. Rule 1. Framing of issues. Issues arise when a material proposition of fact or law is affirmed by the one party and denied by the other. Material propositions are those propositions of law or fact which a plaintiff must allege in order to show a right to sue, or a defendant must allege in order to constitute his defense. Each material proposition affirmed by one party and denied by the other shall form the subject of a distinct issue. Issues are of two kinds, issues of fact and issues of law. At the first hearing of the suit, the court shall, after reading the plaint and the written statements, if any, and after examination under Rule 2 of Order 10, and after hearing the parties or their pleaders, a sentence upon what material proposition of fact or of law the parties are at variance, and shall thereupon proceed to frame and record the issues on which the right decision of the case appears to depend.
Okay, so what is our understanding of this?
Issues, read the whole? Okay, there is Rule 6 as well, so I'll be reading that. 2. Nothing in this rule requires the court to frame and record issues where the defendant at the first hearing of the suit makes no defense.
Yes.
So
we've all read it. Okay. What is the distinctive feature of this particular rule, order?
Rule 2, Lordship, I think. There must
Sorry?
be Rule 2 of the order, sub-rule 2 of Rule 1, that there must be material propositions of law or fact which the plaintiff must allege and the defendant must deny.
Okay.
And
so we have also had sessions about, what is statutory interpretations, isn't it? And one of the, most important aspect of statutory interpretation is that the legislature knew exactly what they were writing, and no word out there is without any reason. Isn't it? Am I right in that proposition? If that be so, then can you just underline the word material in all these rules? Can you just underline it at every stage? Rule 1 talks about material, 2 also talks about material, 3 also talks about material, right? 5 also talks about material, right? Would that be correct? Now, can we just remove from this legislation the word material and read it again?
I think for that, Lordship, there is a Rule 3, materials from which issues may be framed.
Sorry? Sorry? Come again?
There
So
is
I'm
Rule 3.
just trying to do an exercise here
Okay, Lordship.
of understanding this law. If you remove the word material, right, then how would it read?
When issues arise when a proposition of fact or law is affirmed by one party and denied by the other.
Right. So then, but then the second one?
Propositions are those propositions of law or fact which a plaintiff must allege in order to show a right to sue, or a defendant must allege in order to constitute his defense. And
so the word material has some meaning there, which has been defined in 2 and explained in 2, correct? It is not every proposition of facts which forms an issue there. It is only material proposition. And what are material propositions? Material propositions are those propositions of law or fact which a plaintiff must allege in order to show a right to sue, or a defendant must allege in order to constitute his defense. Now that explains what Ms. Mahima was telling us. Look at the prayers. What is it that he wants? What is his right to sue? What is he asking for? Which is the law which he is talking about which has been violated? Then we can understand the material proposition of fact. If you understand the material proposition of fact as explained in Rule 2, then are those propositions of law or fact which a plaintiff must allege in order to show a right to sue, or a defendant must allege in order to constitute his defense. So not every defense. He may say 200 things. In a case for eviction, right, when eviction is only on the ground of non-payment of rent, right, whether he visited the defendant 10 times or did not visit the defendant 10 times may not be material, but may be denied. So we have to make this distinction between proposition of fact and material proposition of fact. And if we get that thing clear in our mind, then I think issues would be framed concisely, precisely, and to the need of that particular case. Otherwise, what happens? The court labors to get answers to issues which are irrelevant. And then we go all over the countryside. It is wastage of court's time. It is wastage of the time taken in judicial proceedings. So we need to also now develop a habit of being precise. What is all of us talk about being precise. How can we be precise when we, in our judgment stage, when we at the stage of framing of issues were not precise? We framed multiple issues on a short question of fact. So we cannot be precise. We will have to then labor into getting evidence for that issue. Then we will have to labor to decide that issue. Was the plaintiff correct? Was he right? Did it actually happen? Did he visit that person 10 times? And you know, facts is never in black and white. So a whole lot of confusion which mars our ultimate judgment. So I think judgment writing, as I keep repeating, starts from day one when the trial court is brought the files on their table. Once you take cognizance, your judgment writing starts. The more you apply your mind at every stage, you can be exactly what all of us who presented us this beautiful presentation. Each of the presentation was anything fantastic. But to reach that level of accuracy, to be that perfect, we need to be working from that stage. It can't happen overnight. When you suddenly start writing judgment, then how do you do? What do you do? Evidence are in bulk. There are 50 pages of examination in chief. There is another 200 pages of cross-examination by equally competent lawyers. How can you be precise? So when we can't be precise, then what we do, we extract. And then it becomes lengthy. So, while each of you made this fantastic presentation, I think each one of us also need to concentrate on what we said in this presentation. What you said was perfect. We need to attain that perfection. I think that is what really, because I think it is important that we understand the implication of not concentrating in our matters in the beginning, hoping that in the end I will write a judgment because I'm so used to writing judgments that I can do it. How does it matter? In criminal cases, who discussed criminal cases with us? Framing of charge. This time? Is Mahima. So we talked about these provisions of law, 211 and onwards, isn't it? Framing of charge. What is a charge? Ms. Naiditya, can you tell us?
CRPC defines charge under section 2B, which says that charge includes any head of charge when the charge contains more heads than one. But this does not actually define what the charge means. So I think on my understanding, charge means the offense that it is a formal accusation that we accused the individual of, and it consists of the offense that the accused has committed, when, where, how the offense was committed.
Okay. If a person commits multiple offences at different points of time, can a singular charge be framed from that?
No, Lordship.
Why?
Lordship, because it is given in the CRPC.
Oh, where is CRPC? Can you read it out to us?
Separate charges for distinct offences, section 218, Lordship. Lordship, it depends on the circumstances of each case. If it is the same accused, then committing different offences at different places, at different times, then it can be, the same charge can be.
So according to you, if it is the same accused who has committed multiple offences, then one singular...
No, Lordship, one trial, but charges need to be different. I was just confused a little bit.
There is a distinction between one trial and one charge.
Charge, yes, Lordship.
The question to you was, can a singular charge be framed for multiple offences committed by one man?
Lordship, section 219.
219.
Yes,
What
Lordship.
does it say?
It just talks about 3 offences of same kind within year may be charged together. And 220.
What does that mean?
The condition for a charge that can be framed together needs to be within a space of 12 months. The offence needs to be
Can we read that provision
of
again?
12 months.
Can we read that provision again?
3 offences of same 3 offences of same kind within a year may be charged together.
No, that is the heading.
Yes, Lordship. When a person is accused of more offences than one of the same kind committed within the space of 12 months from the first to the last of such offences, whether in respect of the same person or not, he may be charged with and tried at one trial for any number of them not exceeding 3. Is what it says, Lordship.
So does that explain what you just tried to tell me? That you can frame one singular charge? The provision.
Lordship, 220.
You are running from one provision to the other.
Lordship, but the answer lies somewhere in between 280 and 220.
Sorry. I'm trying to understand one provision you try to throw at me and you come to the other. How will I understand the first provision? I have not even understood 219. Would the senior session judges explain 219 to us?
219 says 3 offences of same kind within year may be charged together, and section 220 says trial for more than one offence, which says if in one series of acts so connected together as to form the same transaction, more offences than one are committed by the same person, he may be charged with and tried at one trial for every such offence.
Yes, that's not what the provision says. So can we explain this?
I think, Lordship, the language itself is clear. It's out of one transaction, Lordship, in a series of acts so connected together.
That's not the... point I'm trying to make. Can a singular charge be framed? A single charge. I hereby charge you for the offence of murder, rape,
No, Lordship, that cannot be done.
and theft.
No, that cannot.
Because it happened in the same transaction.
No, Lordship.
That's the question I'm putting to Ms. Mahima.
Distinct. The charge has to be distinct, Lordship.
Why should it be distinct is the question which we are struggling to answer.
Because rape is a offense, different offense, Lordship. Murder itself is a different offense. Theft is a different offense altogether, Lordship. So the charge has to be distinct, Lordship.
Why should it be distinct is the question we are trying to get an answer.
The evidence might differ, Lordship.
No, that's not on the law point. On the law point.
Distinct.
We go back to the same provisions to
Yes, Lordship, the CRPC says charge has to be distinct.
Yes. That's right. So why are we struggling to get the answer, Ms. Mahima?
Yes, Lordship.
When you read these provisions 211 onwards, you have to read each of them and then come to your conclusion. Not one provision and come with your opinion. You have to read it together. Then if you read it together, you will understand that each of these offences must be separately charged. You can try them together if it falls under the parameters of the law. But each of them has to be worried. The reason, and this is not a complex legal issue. Why is the charge framed? You must understand the reason for framing of charges. It is to tell the accused precisely and clearly that you have been charged for this particular offense and this is the reason we are charging you. If we understand the reason for framing of charge, then none of us will even attempt to frame a single charge for multiple offences. Because you will then confuse the accused for which the trial is there. Why are you conducting the trial? We are conducting the trial to ensure justice is done. That no one is punished without a fair trial. Can it be said to be a fair trial if you are going to charge the same accused for multiple offences in a singular charge, which he does not understand? So what is, Ms. Naidya, what would be an outcome of a trial if for multiple offences in one singular charge? What according to you would be the ultimate outcome? And I am talking about judicial outcome.
Lordship, if the single charge is framed for the multiple offences, we would never come to the. I mean, while writing the judgment, I think it should be clearly mentioned that if the person.
How will it lead to a judgment? Question to you is, how will it lead to a judgment when you framed a charge for 3 different offences in a singular charge? Then how will you write a judgment?
Lordship, we cannot write a judgment.
So what do? Abandon the trial?
No, Lordship, we'll frame a distinct charge. We'll alter the charge and frame the distinct charges for each offences.
So how will you commit that? Since you have already framed a charge with 3 distinct offences, which are
216 of CRPC, which says that
all of us have all these tools and gadgets. Okay. Yes, please tell us, 216.
216 says court may alter charge. Any court may alter may alter or add to any charge at any time before the judgment is pronounced. Second, every such alteration or addition shall be read and explained to the accused. That's a different thing. But the first one which says that any court may alter or add to any charge at any time before the judgment. So we have given that liberty, even till the final stage, even after the completion of trial, the charge can be altered.
Okay. Now, how would you do that if somebody doesn't point it out to you? I'm sorry, I'm posing all these problems because it keeps on affecting me. How does it happen in the trial court? Unfortunately, I have not been a part of the district judiciary except as a lawyer trying to, get justice done from all of you. I have not been able to, sit on your chair and, understand the working of actually how a working of a trial court judge really happens. So, I'm sorry. But how do we do that? Because you have so many busy, schedule, you have like multiple problems every day. You've got so many cases on your files. You framed a charge at one point of time, and now it is given on a next date. The next date, the lawyer comes and takes it further on. So how does it happen? If suppose you had made a mistake earlier, how do you rectify under 216 unless a lawyer comes and points it out? But then the lawyer will not point it out because the defense lawyer pointing that out would be harakiri. In the end of the trial, he will get an acquittal because of the wrong framing of charge. So why would he even bother to trouble you and make you aware? So how will you become aware unless it is pointed out to you? It's a problem which I wonder how does it happen? Yes, I made it clear.
Lordship 216 itself says that the court may alter. So I think
That's right. The question is not about law. You have the law with you. The question is of fact. You have at one point of time framed a wrong charge.
Yes.
Nobody has told you about it.
Yes.
Right?
Yes,
it is there in the file. It is going on in a month-to-month basis. You've given a date for the next month. The next month the lawyers come to you. They present their case and take it forward. None of them point it out. A defense lawyer would never point it out to you because if you make such a fatal error, then that would ruin the entire trial.
Yes.
And that's what I'm looking for. So why would I point it out to you? And the prosecutors do not have the time or the inclination to do so. So how will you know suddenly, how will this eureka happen? That you could apply 216.
Starts coming in, I think it will become more clearer. So at that moment, if you feel that the charge has not been framed, we can sumo to consider altering the charge or making any addition.
Does it really happen? Let's ask the senior judges. This kind of correction, does it really happen in the trial court? That suddenly we realize we made a big mistake and we will correct it? How many times does it happen?
Lordship, it has happened a couple of times, at least in my case, during the
In your career, obviously.
Yes, Lordship. It has happened, Lordship. So, at even a later stage of the trial, I have sumo to altered a charge, Lordship.
Okay. But what would be the percentage of cases in which you would have this thing, chance of realizing that I made a mistake?
Not very often, Lordship. That is why at the fact end of my career, I've realized that when you are doing your hearing on charge, Lordship, both the judge and the prosecutor and the defense, all of us should be thorough with our briefs. We're talking about charge sheets, Lordship. At that stage, we just have the charge sheets before us. We have no other evidence. So you should be thorough with the evidence. You should read all your 161 statements. If there are any medical reports, you should read all that. And that is how you come to a prima facie finding on the charges to be framed.
But that's the guidance I was looking for. That was the guidance, and I'm so thankful to the learned senior district and session judge for enlightening us. The younger ones, please make a note of this, because it doesn't happen that, and I'm saying so because I've been a defense lawyer, and I've also, I must admit, taken advantage of all the wrongs the prosecution did. It is to my gain, as a defense lawyer, it is to my gain. So if the court makes a mistake initially, if the prosecution makes a mistake, I am gleefully oblivious of that situation. I'm not going to be, a person of great moral standing and tell the court, you're making a mistake there, correct it, otherwise I will be punished. I'll get the advantage of it as a defense lawyer. So you will never have that guidance from anywhere except from your senior judges. And what I request you, when we have this kind of gatherings and meetings with senior law judges, have some interaction. Listening to lectures, listening to all these sessions is all right. But when we get together, it's a time for you to interact with the senior judges and take with you that vast experience which no amount of teaching in the Judicial Academy can actually give you. So interact with them, pose your problems, understand how they have dealt with it, and move forward. The great amount of learning they have, and it should not go to waste. That's my earnest request to all of you.
At this point, I'd like to share a recent experience that I had regarding charge. This is a case in Mali. A charge sheet came, it was filed under POCSO because prima facie it was a POCSO matter. And so when we heard the prosecutor, everybody was like, yes, it's a case of POCSO. But when you go to the 161, you could also have framed a charge for human trafficking. Because when human trafficking 370 has been altered, the section has been altered, amended, Lordship, about 3 years ago, I think, Lordship. So when such charge sheets come before you, POCSO cases, if you look at it carefully, it can often be a case of human trafficking also, Lordship. So that is when I decided to frame a charge also under human trafficking. So I would like, I'd like to share this with the Honorable District Judges, that when you get POCSO cases, if you could just carefully read between the lines and go through your 161 carefully, you can also have a case of human trafficking. And because human trafficking is not 370 is not a section that is often used by the IOs, because they are not even aware about it. And it's cast a huge umbrella over the offense. So I think if you can look at it, then it will be very helpful, Lordship.
That also brings me to another, thought, which has occurred to me in several of the charge sheets that I have read. While the charge sheets and the documents attached to it sometimes narrate the facts in great detail, the prosecution is for offences which are very limited. It does not actually, and maybe this is a mistake, maybe it is a purposeful mistake, but I think a judge reading the charge sheet should not read the last paragraph only, should also read what is written in the entirety of the charge sheet, what is there in the 161 statement, what is there in the 164 statement, and come to their own opinion. Would I be right in saying that in many cases, the senior judges can again tell me, charge sheets are filed on sections which sometimes are milder. We have not seen the reason, we have not understood the reason, we really can't go and see the working of the police, is that all that is not before us. But can we be a little more cautious in our approach than reading just the thing and framing charges only on the section which the prosecution desires you to. Because if you read, I've seen this is in not one or two cases, in multiple cases, we have framed charges on cases where the charge sheet reflects much more. So I think we need to be a little cautious and careful when we are reading the charge sheets. The younger ones, be mindful of these things. I think it is very important for you to read everything. Marshalling the facts, so all of you use these phrases. That's it. How do we marshal the facts is something which we need to get training from the senior judges with their experience. You see, these are only small little things in my experience as a trial court lawyer I have noticed. So I can say that. But the senior district session judges will be able to tell you much more, because they've had huge amount of experience in dealing with all kinds of issues that troubles them in a day-to-day basis. So again, use their experience to gain knowledge. We can go on and on. If there is anything else that we need to discuss, we can discuss it. Mr. Karma, anything that?
I do not have any much to add, Lordship, because I think.
To the next session, because I think we overshot the time.
Okay.
So, do you all want to take a break, or do you want to carry on? Lordship, with your permission, should we carry on, or would your Lordship like to?
Whatever, the choice is yours. I am sitting in my chamber. The choice is yours.
So,
you want to take a tea break? Please take a tea break.
To the second part, judgment writing in. Judgment writing is. I think there will be some amount of overlapping because the subject has already been covered in the first session. So I won't go into the details. Fortunately, so I don't have to talk much about it, since I'll be skipping major portions of it. All right. You already know the definition. Can you start? Do you have a pointer? So we've already covered the definition. All right, where it's defined. Now here is. There are two judgments actually. I'll start with two judgments. This is Shakuntala Shukla, State of UP, because these are fairly recent. It's of 2021, and State Bank of India versus Ajay Sood. This is one of 22. Interestingly, the Honorable CJI himself was on the bench when in these two matters. Basically, the point is, he says, what is a judgment? It is your judicial opinion which tells a story about the case, what it's about, and how and why you've decided the issues. And so it's a decision by a court on the question or questions or issues before you, all right? So we've come to know what is a judgment. What is the purpose of a judgment? Everybody knows what's the purpose. You've given your views. So you've come to a final conclusion of the legal issues, isn't it? Now, since I'm dealing with the civil side of it, in civil proceedings, what does it do? It summarizes the court's decision, reasoning, and conclusion, obviously, isn't it? And like it's already been said, it is not just for your benefit or the party's benefit, but you're writing it for also the appellate court. You must bear in mind that one of the parties is going to be upset about your judgment. Somebody is bound to go to the appellate court, isn't it? So you must write it with in such a way that the appellate court will also be able to understand how and why you've arrived at your decision, other than, of course, the judgment being for your judicial fraternity, right? So like Rosalind Atkinson, the judge of a Supreme Court of Queensland, explained, what is the purpose of your judgment? It is to spell out the judge's thoughts. Now you are basically, whatever you have thought, whatever you have found, you have put it down and you've clarified it. So to clarify the decision to the parties involved, you are communicating what you have found, what you have thought, what you have seen. Alright, so you have communicated in writing, and how? By giving your reasoning, rationale behind your decision to the public and provided the grounds for consideration for the appellate court. Now you have laid down the grounds, isn't it, for the appellate court also. So your judgment must be such that even the Court of Appeal, when it goes there, it should be clear to him, clear to them as to why you have come to this decision. Alright? I'm just giving you like very broad, general. So we've said very fine, okay, we know what is a judgment, we know what a judgment is, what is the purpose of a judgment. How do we begin writing a good judgment? All of us have written judgments, perhaps maybe not for some of the younger ones. That's why we are here to hone our skills. Everybody knows how to write a judgment. The purpose of this program is to hone our skills, to improve what we are doing on a daily basis, isn't it? So it's everything like you in school, you have writing essays, everything starts with an introduction, everything starts with the body, and everything starts with the conclusion. So your introduction is very important, because that is what will give you, set the tone for your judgment, isn't it? But you cannot have a long introduction where you've put half the body into your introduction, isn't it? So you start with a brief, clear indication of what you're going to talk about, what you are going to write about, or what your subject is, what is the judgment about, isn't it? So basically you set the stage. And okay, the actor enters the stage, isn't it? So you set the stage, alright? The next is, you must begin with a clear recital. What is a clear recital? It has been said before me by Ms. Jamyang and Mr. Seshang, isn't it? Short, clear recital of the facts. Unless you give the facts, you won't be able to, the party is not going to understand what is it you're going to talk about, isn't it? So you give a clear recital of the facts as to why the parties have come before you. What is the cause of action? Now we're talking about civil matters. Why has the plaintiff come before you? What caused him? What was the action that caused him to come running to your courts? Isn't it? The cause of action now. So to do that, you give the facts, narrate the facts briefly, okay? So for the beginning, you have the 3 C's. Oh, okay, it's gone up. Clarity. Now we are talking about write a good judgment, how? This is just a pointer. Clarity, conciseness, and context. We've been underlining this again and again. Clarity, be clear. You can lose your way while discussing facts. It is like, this is a plot of land and there was a big oak tree, and next to the oak tree there was a thatch roof. There are so many extraneous matters you need not discuss. For example, I'll tell you, recently, it's a criminal matter, let's say a charge sheet came, the IO wrote, oh, the girl, she became pregnant, but first she had nausea, then the next month she had a cold, she was taken, but the nurse did, this is a fact, nurse did only a hemoglobin test, so they went back. Then she fell ill for a while, she took antibiotics, and for 1 month she was okay, but after antibiotics, after the taking the course of antibiotics, she was well. And finally when she was taken in the 3rd month, after two months to the PHC, they detected that they conducted a urine test and her test was positive. Now whether she had a cold, whether she took a course of antibiotics, you know, whether she her hemoglobin test was taken, all that is unnecessary. That is how the IOs write that. Similarly, it is not necessary for you to write whatever is there in the pleadings. There is a tendency for many of the judges to reproduce all the paragraphs of the pleadings. You don't need to do that to do your facts, alright? You come out what is relevant for your facts, for your in your storytelling. Come out what is relevant only and give that. So that is where you get clarity, because clarity is the key to good judgment writing, isn't it? And context helps the reader understand what is the issue. The context. What is the issue? What is the main zamra between the parties? So that is your context. So context and conciseness. This brevity. Brevity means depth. So you can, it has to have some depth in what you are saying, isn't it? So the 3 C's, clarity, context and conciseness, will give you a brief introduction. You'll be clear, you'll be sound, and you will be brief, isn't it? So we are talking about language all the time, isn't it? Language and style. Everybody has style. Lordship has wonderful style. He has a wonderful vocabulary. Not all of us have that. But the key to this is to keep it simple. Now to, like Ms. Naritya gave an example, keep it simple, isn't it? Don't go into like superfluous words and all that. And judgment writing, basically you must remember, it is a formal document. It's a formal legal document. So there are certain traditions that we have to follow. Like we are saying, should be storytelling, it should read like fiction. But at the same time, we must bear in mind that it is a legal document. There must be some formality attached to your writing, isn't it? So maintain a formal tone. It has to be, because see, it says we have to adhere to specific conventions to ensure clarity, because authority, because you're a court giving your opinion on certain legal issues. And then there must be some amount of professionalism. You cannot write it like you're writing a nice story about, like James Hadley Chase and things like that. You have to be professional in your storytelling, isn't it? So maintain a formal tone, use proper legal terminology. If there's a legal term for it, use legal terminology. Then keep your language objective. Now you're the third party. You're in the middle. You have to be objective. You have to maintain an objective tone. Of course, the logical structure is that there's a certain structure that we follow in writing our judgments. We all know that. I don't have to talk about it. Avoid repetition. Now, this is something that happens very often. When you're trying to give your cause of action, the plaintiff has done that in his paragraphs. You don't need to do that. Don't repeat it. If you find that in 4 paragraphs he's trying to say, give you one particular circumstance, stick with that. You don't have to get repetitive, all right? Because that will make it boring, isn't it? And lengthy. Now here, avoid personal knowledge, surmises and conjectures. For example, say many of the judges, you go to Sikkim, on your Gangtok, Sikkim is a small place. The suit property might fall on the way to your work, isn't it? While driving, Judge Sahab, oh, the plaintiff, I can see, bichara, he is working, building ma, plastering gardaisa, wrong laundaisa, you pass by, isn't it? While writing your judgments, don't let that personal knowledge, this is just a small example, but there are so many other personal knowledge you might have about, don't let it enter into your judgments, okay? Don't use personal knowledge, surmises. Oh, because he was plastering every day, I'm sure he is the one taking care of the property all the time. Or I see him digging in the field, he is the one in possession. I know. I assume he must have been in possession all this time. Don't surmise. You have to go by what is presented before you, by the evidence led before you. Do not use your personal knowledge, do not use conjectures, do not use surmises, all right? And no criticism of parties when you write your judgments. Do not criticize parties or use harsh words against them. Oh, the defendant is an evil uncle who, he has usurped and snatched the land of the poor brother's orphaned children. No criticism of parties because you are not supposed to do that. All right, you must use restrained, sober, dignified language. Objective, dignified, sober language. We always say, simple, right judgments, simple judgments, right with clarity. This is how you go about it. Use restraint. How to be professional? Use restraint. Do not use criticism. Do not use slang. There have been instances where judges use colloquial terms. Those words skip me now, but you must not use you should not use colloquial terms. You should not use slang, all right? He said he'll arrive in a jiffy. I found that he arrived in a jiffy, just by way of example. don't use, you must use professional terms, you must use proper language, all right? And using headings and subheadings. Now this is something Lordship I've noticed in his judgment, he does that. I have not done that, many of us do not do it, but I find that it is extremely helpful. So you can break up your judgments into headings and subheadings. What that does, I find, is that it brings immediately clarity to the person reading it. You can go in, you can immediately jump to the portion that you want to read again, isn't it? So you can use aids like this. You can use headings, subheadings, and consistency in spellings. Check your spellings. Of course, now with spell check and with the apps, this problem is not there, although we are still struggling with the English and American spellings, isn't it? Apart from that, try to maintain consistency in spellings. And now I will give you an example which I keep just yesterday. S-A-N-J-A-Y. How do you pronounce it? S-A-N-G-A-Y. Sanjay Sange. With a small miswriting of G and J, the entire name changed. Now sometimes your IO or your plaintiff will write Sanjay Sange, typist will write G, they will add J. Be very careful about this. We all know it may be Sanjay, but in between it will come as Sange. His surname is S-A-N-G-A-Y D-A-R-J-E. How will you pronounce that? Darji. D-O-R-J-I-E? D-O-R-J-E-E? So this is what happens. Often, very often in one judgment you will find D-A-R-J-E, D-A-R-J-I, D-A-R-J-I-E, D-O-R-J-E-E. There is no consistency in spelling and many of us tend to overlook this. So kindly pay attention to consistency in spellings of proper nouns, especially names and places. G-Y, because, okay, say I come from gazing. How would you spell gazing? G-A-L-Y-S-I. How would you spell gazing? Exactly. How would you spell gazing? So there are so many different ways of spelling one particular name of a place. In your judgment, kindly maintain consistency. When you are mentioning proper nouns of names and places, you have to maintain consistency. And when you do that, what happens? You are showing your professionalism, you are maintaining a formal tone, and you are basically being consistent, isn't it? So, now read all the 3 sentences. Avoid unfamiliar terminology, verbosity, phraseology, and legal jargon. Keep sentences concise and to the point to enhance readability. Use easy, simple, clear, straightforward language. All 3, like Ms. Naritya used the 2 examples, they all mean the same thing. But your first one, look at the terminology. After reading the first 2 verbs, you will skip it, isn't it? Because it means the same thing. But whereas when you read the last one, or maybe the second one, it's easier for you to read. You find you're more comfortable with either of these sentences, isn't it? Similarly, you must bear in mind the reader is not a judge, apart from the advocates, you're not from the legal fraternity. So the party, your party, who, especially the one who has lost, will want to know why you have not decided in his favor. So he's going to try and understand your reasoning. So in order for you to justify why you have given your finding against him, use simple language. Then to some point he might even be justified. He might feel like, okay, oh, judge sahab this karanle po raisa. But if he's not going to understand that, he's going to be one dissatisfied litigant, isn't it? So these are small tips that you can bear in mind. Now we went into drafting issues. I'm very grateful to His Lordship for discussing the drafting of issues at length, because drafting issues, what is it basically? It's formulating, isn't it? What is the main dispute between the parties? We went on saying main, but like Lordship has pointed out that in the relevant provision, it is the word material. What is material? What is core? What is at the root for the cause why the two people have come before you? All the rest is extraneous. That is why you have 13, 14, 15 issues. And that is why while drafting the issues you find that it is overlapping, so you will write, I've been guilty of that also. So I'll write issue 1, 4 and 5 taken up together since they overlap. So in order to avoid this, go to the core issue. What is material to the issue? What is the main dispute between the parties? And in order to do that, how do we do that? How do we go to the core issues? We have order 10 also, isn't it? Why do we have order 10? Things which are already admitted, no point. But often you find perhaps it's on account of the pressure by the bar, or perhaps because your list is looking at the list of suggested issues, we tend to tick off, isn't it? Don't go by that. Because look at order 10, there are so many parts that are already admitted. Yes, it was ancestral property. It was not separate property. Yes, it belonged to a great grandfather in a suit of partition maybe. Already admitted, you don't need to go frame another issue about it, because you'll find that eventually when you're deciding that issue, you'll find that, oh, it was actually already, it's an admitted position. It's a waste of time, alright? So go to the core. See, issue drafting is the process of formulating clearly and identifying, this is the main thing. Identifying the issues can be based on fact and law, isn't it? Legal issue. For example, again, suit of partition, whether it is ancestral property or separate property maybe. Legal issues, isn't it? So, factual issues. So, it can be either on fact or law, but go to the material issues. Those which are not material, no need to. You are there to meet between the two parties and say, no, this is not necessary, this is necessary because this is not core, and eventually they will agree. Both the parties, lawyers will also agree. So, when do you frame issues? This is for the younger ones. When do you think you should frame issues? You discuss your facts, and from the facts you call out, isn't it? These are the points where they are fighting, isn't it? Where they are disputing. So, immediately after narration of your facts, and it's always advisable to decide preliminary issues. Now, you also have preliminary issues like jurisdiction, limitation. So, you decide those before, not along with the issues on merits, isn't it? Then, again, we've gone back to this. Identify the core legal issues, ensure relevance. How is it, how do we ensure its material? How is it relevant to the parties, isn't it? And how do you consider that? From the parties' arguments. What are they saying? If they're not arguing about it, no issue, isn't it? And another thing, organize your issues sequentially. Start from the beginning so that by the end you will reach, obviously we'll end with the last issue, reliefs, isn't it? So always be sequential. I always tell my advocates, don't jump from A to Q to B to Z to D to W. They tend to go in a zigzag manner. It is for you to organize it sequentially, even your facts, whatever it is, so that, again we come back to the 3 C's. It helps you bring clarity. If you're sequential, if you're, for example, the year of incidents, circumstances, from 2019 this happened, 20 this happened, 22 this happened, finally in 24 they have come before you, isn't it? So try to maintain consistency and keep things sequential, alright? So again we are going, I won't go into marshalling of facts because we've gone, what is the purpose of marshalling of facts? We've gone into all that, isn't it? Organizing it, making it easier for the reader to understand. And again I say, organize your facts in a chronological order. Chronological order, alright? And keep it thematic, right? Then Now how do we, I will skip all this because you've already gone into evaluation of facts and what to do. How do we evaluate facts? Just briefly for the younger ones. When we say evaluating evidence, how do you evaluate evidence? What kind of evidence when we say evidence? You have your oral evidence, you have your documentary evidence, isn't it? So you have to consider the testimony supported, if there any is supported by documents, if any, isn't it? And then if you have any other exhibits, you look at that. Then you have expert opinions. So these are things you discuss in your evidence, isn't it? So you assess all this evidence. Now you're deciding your issues, isn't it? We've done the introduction, we've done the body, we've framed the issues. Now in the issues, you're discussing the evidence. Now when you're discussing the evidence, what do? You look at the evidence, like the testimony. Okay, what is it? Is the testimony, is it supported by a document? How is the document proved? Did the witnesses come forward? Is the scribe there? Is there testimony there? Isn't it? Have they proved the signatures? And if you are satisfied that the document is proved, the signature is proved, it is admissible, the laws of evidence are applicable. What is the section applicable? You apply the law, you apply the section, you see what is the evidence, you see what is the exhibit. If you are satisfied, then what do? You give your finding on the issue, isn't it? And when you're giving the finding on the issue, like they have been saying, you have reasoned out, isn't it? When you have discussed the evidence, you have reasoned. Yes, I'm satisfied. The document has been proved by the scribe because he has come and proved it and said it. I wrote it. Yes, the two witnesses have come. They have said that I was present when it was written. So the plaintiff is correct when he produced the document. So you have found it in favor of the plaintiff, or you say the plaintiff has the onus which was on him, he has satisfied it, isn't it? Like that. So that is how you. Of course, the seniors all know, I don't have to teach you how to do it. This is basically for the juniors. This is how you assess your evidence and you decide each issue. Alright? So clearly identify, of course, you have to describe. Now you're saying testimony. Whose testimony? I find in the plaintiff's testimony that this document is proved. Don't be vague. Refer to the particular witness, if any. See, clearly identify and describe the parties, their roles, the relevant events and transactions. If it's the scribe, say plaintiff's scribe, or if it is the defendant's witness, say the defendant's Kutyadar came and said, no, I have been earning the property, not the plaintiff. So if there's a specific witness, refer to that witness. Be clear about the identification because this gives you sound reasoning when you're giving as to why you're accepting either party's evidence, isn't it? So again, avoid unnecessary repetition. And so a well-structured judgment, what does it do? It gives you, provides a detailed account of facts, legal issues, and your court's findings, which are supported by careful appreciation of the evidence. So when you do that, when you discuss the evidence carefully, then what you have done is, it ensures the judgment is both fair and legally sound. You can be fair, but you might not be legally sound, isn't it? So, now coming to the end, reasoning and conclusion. We've gone into this again, but like I say, like they have been stressing, reasoning justifies your finding, isn't it? So, judges must give your reasoning and to the best of the ability without fear. Now, without fear, bias, prejudice, personal perception. Why do I see this is, again, sorry, I will underline one aspect here, avoid media orientation. This is something I have added here because today with social media, and everybody so involved, we are equal victims of social media, isn't it? Every free time we want to go, whole day we've been deprived of our cell phones. At the end we want to see what's happening on WhatsApp and who sent our messages and all that. And in between you might come across some, say, Voice of Sikkim article on some incident which might fall within your jurisdiction. Be very careful about this. We're human beings, isn't it? at some point we might be influenced. So here you have to be very careful. Avoid media orientation. Don't get pressurized by what the media is saying. Because many judges in, not just Sikkim, all over India, and I don't know about globally, but at least all over India, many of the judges seem to fall prey to trial by media, isn't it? So there you have to be careful. So if you feel that a particular case is being reported almost daily by the media, try not to get too involved in that or abstain, because I have had cases where they've come to me for bail saying, look, this is what happened in social media, in Voice of Sikkim, this is, we have video recorded it. I said, no, I don't watch, I don't want to see also, because you have to go by what is before you, presented before you, all right? So, I won't go into analysis because that's reasoning, isn't it? So, recording of findings, okay, why do we say recording of findings, giving your reasonings is important? This is the reason. It is crucial for transparency, accountability, and creation of legal precedent. Also, and it is vital, the reasoning is vital because it ensures the court's determinations are clear, justifiable, and it can be scrutinized by parties involved if necessary by appellate courts. Again, stressing, the appellate courts must know why you have come to a finding. Very often judges tend to say, oh, PW1 has said this, PW2 has said this. They'll go through pages of evidence, and I have found, on the basis of the evidence above, that the plaintiff has proved his case, and this issue is decided in the affirmative in favor of the plaintiff. You have just reproduced the evidence. Where is your application of mind? Where have you been satisfied? What evidence, what in their evidence satisfied you? You have to give your reason for that. You have extracted maybe, you have put it, but what is it about that that satisfied you? If you haven't been able to show that, how will the party be satisfied? How will the appellate court know the reasoning? The appellate court will send it down saying, you have just reproduced the evidence. And this is something early in my career, even I have done that when I first started. Because those days, unfortunately, we didn't have any training. So that is what we started doing, and that was what was done. But now you all are very fortunate, so maybe this is how, you can discuss the evidence, all right? So well-documented, this is why I say well-documented findings are a cornerstone of well-structured and legally sound judgments. And finally, you have given your judgment, you have given wonderful reasoning, you have framed your issues wonderfully, but there's also something to be borne in mind. Order 20 says that the courts must make every endeavor to pronounce judgments within 30 days after conclusion of the final hearing of the case. Now here I know that all of us adhere to this timeline, but sometimes there may come a time when you are not able to adhere to, and then you have only in exceptional cases and extraordinary cases can it be extended to 60 days. But beyond that, you should not. Why? Because early timely pronouncement saves the judges from unnecessary criticism. There have been instances where courts have sat on judgments for months, and then the party starts speculating. There have been all kinds of rumors saying, oh, it is because of this, or oh, it is because of that, or there, Marty got a pressure, all these kinds of things. Or the poor judge might just not be finding enough time, or still might be struggling with some particular issues, isn't it? That's what happens. So that is why a timeline has been set out for us in the code, all right? So we must try to adhere to that. That will protect you from this unnecessary speculation. And then, of course, now, more or less, I've run through my presentation. There are some citations which will be taken over by my colleague, Ms. Shamita, and over and above this, she'll also give her input into this and clarify further on this. Thank you very much. If you have any questions, then we can discuss it later.
With Lordship's kind permission, without wasting much time, I would like to go ahead with my presentation. I must say I am the fortunate and the unfortunate one, because then as far as the topic goes, civil judgment, writing civil judgment, I'm the last speaker. And the fortunate thing is that everybody else has covered this topic. So there is not much for me to cover. And so, few things I would want to walk this, the House through, whatever I have learned. I must say this is my learning process, because the way this training program was conducted today, I'm sure this was Lordship's idea, and I must say, I think many of us, we would all feel that it was a wonderful idea, because for me it was a learning process. I'm also infant as far as writing judgments are concerned. I'm just learning here. So what I learned from whatever was deliberated since 10 o'clock this morning was, one thing I learned from Ms. Damian was, it is an acquired skill. Nobody will be able to teach you how to write your judgments. It is your own style, and it will be acquired through experience. That is what I learned. And the reasons, what she was discussing about, it should be reasoned. The clarity which she was talking about in our judgments writing. And one thing which Lordship has always told us, and Ms. Zamian repeated again today, was whom we write to. Our judgments are for whom. It's not for ourselves, but it is for whom that we are writing to, we should be mindful about. And from Mr. Sesehan, what I would want to again point out is, whom are you writing for? That is again, which he said, and lucidity of explaining whatever we write, table of contents, reasons, the most important thing, issues, what Mr. Sesehan discussed about. And again, the other factor which Ms. Damian talked about while writing judgments, not only in civil but also in criminal, both civil and criminal jurisdiction, would be that we have to bear in mind the Indian Evidence Act, which we have to consider in both our jurisdictions. Again, it was, as Ms. Nairitya said, clarity, simplicity, and the example which Lordship just pointed about, that was really fantastic, because I could relate to that. We would always want to be explained simply. That is what her example was there. And from Ms. Mahima, which though her jurisdiction was criminal, both Ms. Nairitya and Ms. Mahima's, but these are the points I feel we should also consider while we sit in our civil jurisdiction, though their points were in criminal jurisdiction. What Ms. Mahima said was, judge has to consider the entire evidence. Entire evidence, as ma'am was pointing out just before I spoke, entire evidence, that is what we'll have to consider. Volume, weight, effect of evidence, that is also what she pointed out, and which was again substantiated by what ma'am just discussed with us. And take all the material facts. We have to take in consideration all the material facts while we write our judgment. And as ma'am pointed out, it's a legal document, so it has to be dealt with appropriately because it is a legal document. Again, the most important thing about which I understood from ma'am's deliberation is heading and subheading. I feel I will consider doing this, but I do not know how well will I be able to do this. This was something new I would learn, heading and subheading, and the spellings, of course, and the timeline, which is very important and which I feel maybe at times we skip that. And that is the most important thing. Thank you so much, ma'am, for pointing that out. Before I go to the citations, I would just like to discuss few things. As we sit as an appellate court under civil as well as criminal jurisdiction, and that is what happens with lordships also, when our judgments go up. So, few things what I have learned and what I have experienced is, again, issues comes. The most important thing is issue. As deliberated today, I am really grateful because that is a learning point for me as well. Issue, I feel, is the heart of a judgment. because then whatever you frame, you'll write according to that. And if you have so many issues lined up before you, I feel you'll confuse yourself. That is what happens to me when I write. If I frame more issues in civil, and at the end of the day, when I sit writing on that issues, I will be confused which is what and which is what. So, thank you, Lordship, and to Ma'am, and everybody who deliberated about issues. That was the most important thing for me. And the other thing is reasoning, which Mr. Sesihan was discussing. I feel reasons in our judgment would be the heart of our judgment. When issue is, it will be the soul of our judgment. When I see this, I feel heart will be the issues and soul will be the reasons which we put there. So our judgment is a legal document which should be based upon all the evidence. That is what I learned today, and it should be the issues which we focus upon and the evidence and how we write. The other thing is, while we discuss and frame issues, the onus, fixing of onus, which I think it will be easier for us. If we fix onus while framing issues, that is one thing that will help us, because certain party will have the onus to prove it, and if he doesn't prove it, that is for us to see, and it will make things easy for us. The other thing which I found while dealing with issues here is, at times we see when we discuss issues, as Ma'am was pointing out, we don't discuss it deliberately. But what I feel is, whenever we discuss any issue, we need to discuss all the evidence there. We frame one issue, and at times we tend to discuss that issue in one page or in 2 pages. And I do not know whether we conclude that issue properly or not. That is another thing what I feel. So whenever we discuss our issues, each issue has to be discussed clearly, and we should be clear what are we discussing about and who has proved it and who was not able to prove that issue, so that we have our soul there, the reasons which we give at the end of our judgment. The applications under 711 is another thing I just wanted to discuss here. Whenever an application under 711 comes before us, and it comes very often, this is the tendency, it comes very often, and I feel whenever we are considering 711, we need to be mindful, because then it is somebody's case we are dealing here, and if we throw that case at the threshold under 711 without considering it properly, that will affect the person who's come to the court. That is what I feel. Because then what I feel is, as leadership has always told us, a person will never want to come to a court until and unless if it is necessary for him or her to come before the court. So whenever we are sitting or presiding over a 711 application, we need to be mindful and apply all our mind, whether at the threshold. At times the provision says at any time of the judgment we can apply this, we can decide this application, but at the threshold, when I'm saying this, when we decide this at the threshold, I feel we should be really mindful of whatever we are doing and the evidence we discuss there before we throw a case out of our court. This was whatever I could learn from the presentation today, and one thing I have to acknowledge and appreciate here, because we all are here together, and one thing that helped me this time, the month of February, I'm still to give my judgments, but one thing that helped me in my writing in my judgment is, I have to acknowledge this. That is what I'm doing here. I have been presiding over POCSO cases, and this time I am dealing with a judgment wherein 164 has come before me, which is done by learned magistrate, Ms. Ranjita. I have to say this, because then the child in this case is very small, but the way she has dealt with the child and her observation, not only her observation, her notes, that was what I was discussing with Mr. Sesihan the other day when he came to me. The notes, whatever she had, because a 6-year, 5-year, 4-year child will not be able to express everything to you. But her evidence, her 164 corroborated everything there, because then she has made entire details of how the child behaved, what the child did, how did he sit, how did he or she speak, and that helped me to see whether there are other evidences corroborating with that fact or not. Because what I feel is, under POCSO, though this is not my jurisdiction, jurisdiction, but still when Lordship was asking us some time ago if there's anything to share. So this is what that had come to my mind, and I thought I will share this when I speak. Because what I feel is that child who's a POCSO victim will go through all the channels, and ultimately when he comes to a court, a magistrate will be the first thing the child will see. So how are you connecting to that child? Because the sessions judge, a POCSO judge who sits over there will be dealing with only the 164 before the child is coming to the POCSO court. So 164 when it comes before us, and if that has all those details there, it really helps. And I'm pointing out Ms. Ranjita's because then that is the one I'm deciding now and which is helping me. So it doesn't mean others have not done it, others have also done it, but then since this was fresh to my mind, so I'm sharing this. So that is just experience sharing out of what I have felt sitting and presiding under POCSO jurisdiction. So coming back to the citations and coming back to my topic, the first citation, if you could just run through it. The first citation is of Ashokpura versus Rupa Ashokpura, 2022. In this case, the Honorable Supreme Court emphasizes the importance of speaking in one voice and ensuring consistency in the judgments delivered by benches of coordinate jurisdiction to maintain the integrity of judicial system. The other judgment is State of Punjab versus Jagir Singh, 2023. The court highlighted the need for judgments to be precise, logical, and not deviate from relevant issues. It emphasizes the digression into unnecessary matters could dilute the clarity and essence of the judgment. The third judgment is Municipal Corporation of Delhi versus Gurran Singh. In this judgment, the court highlights that judgments should not only resolve disputes but also provide guidance on legal principles fostering clarity and predictability in law. Fourth judgment, this is Supreme Court Advocates on Record Association. From this judgment, what Honorable Supreme Court has said is, although this case primarily dealt with the Memorandum of Procedure for Appointment of Judges, it emphasizes the importance of transparency and accountability in the judicial system, indirectly impacting the writing and pronouncement of judgments. And the last judgment, Sudhir G. Angur, 2006, it's in the slide. This case emphasizes the significance of accurating reasons behind the decision. The court stressed that reasons should not be vague or pre-functionary, but should be based on facts and laws demonstrating a logical and coherent thought process. That is my presentation. Thank you so much, ma'am, for a wonderful presentation, because I feel under civil as well as under criminal jurisdiction, there were certain things which we could have known. It is there in us, but then having this session being conducted today, we would have again skipped that from our mind. Thank you so much. Thank you, Lordship.
Good afternoon, Honorable Lordship, Honorable Judges, learned judges, and my learned colleagues. So, starting with the topic, judgment writing in criminal cases, I think this is the third time that it's being presented, so it might be a little repetitive. So, please kindly bear with me. So, what is a judgment? The meaning of judgment as per law.com is the final decision by a court in a lawsuit, criminal prosecution or appeal from a lower court's judgment, except for an interlocutory judgment, which is tentative until a final judgment is made. The word decree is sometimes used as synonymous with judgment. Now I think the definition of judgment has been elaborately laid down by my previous speakers. So now we come to section 353 CRPC.
the Code of Criminal Procedure, it talks in detail about judgment. It's, I think, I don't think I need to read out the whole provision. It says we have to, the judgment is pronounced when it's delivered. It has to be read out. The operative part has to be read out. The judgment is delivered when it has to be, even if it's taken down shorthand, it has to be signed. And then there are various other clauses. Then we come to Damu Senapati and others versus Sridhar Rajwar. This is a judgment delivered by the Honorable High Court of Calcutta. In this case, the judgment has been defined as the expression of the opinion of the judge or magistrate arrived at after due consideration of the evidence and of the arguments. Similarly, in Dwaika Nath Mundal versus Beni Matlab Banerjee, this is also a judgment of the Honorable High Court of Calcutta. It has been observed that the judgment itself indicates some final determination of the case, which would end it once for all, such as an order of conviction or acquittal. Now coming to the next part, when is a judgment pronounced? So in Anil Rai versus State of Bihar, it's a case of 2001, the Honorable Supreme Court has stated that it shall be pronounced in open court immediately after the conclusion of the trial or on some subsequent time for which due notice shall be given to the parties. Now what is subsequent time? Subsequent time at the most can be stretched to a period of 6 weeks and not beyond that in any case. So why can it not be stretched? I think Madam Bakumpa has already elaborated on this point. What happens? The repercussions of a delayed judgment. So in R.C. Sharma versus Union of India, the Honorable Supreme Court has stated that litigants must have complete confidence in the results of litigation, and this confidence tends to be shaken if there is excessive delay between hearing of arguments and delivery of judgment. The delay is not only against the provisions of law, but it in fact infringes the right of personal liberty that has been guaranteed to every citizen by Article 21 of the Constitution of India. So it is also contrary to the maxim actus curiae nem grabavit, which means that an act of the court shall prejudice none. Now we come to the next part, that is language and contents of judgment. So like I stated already, section 354 CRPC talks about the language, 353 talks about judgment and 354 talks about the language and contents of judgment. So the judgment shall be written in the language of the court, which in Sikkim is English. It shall contain the point or points for determination, the decision thereon, and the reasons for the decision, which has again been elaborately discussed by the previous speakers. It shall specify the offence, if any, of which and the section of the IPC or any other law under which the accused is convicted and the punishment to which he is sentenced. Then, if it is a judgment of acquittal, it shall state the offence of which the accused is acquitted and direct that he be set at liberty. So over here I would like to draw attention to the Sikkim Criminal Rules of Practice of 2021. So here there is a certain format that has been laid down by the rules, which states that the judgment should start with a preface showing the name of the parties as per Form A. So I have extracted Form A over here. Then there should also be a Form B, which is a tabular statement to the rules. So here we state date of offence. It becomes more detailed. So anybody reading the judgment will be able to see the chronology of the case. Then the next is Form C, which is an appendix that provides the list of witnesses, exhibits and material objects, which is again very important, especially when our appeal is being read by somebody other than the parties or the concerned judge, because then they will be able to refer to who PW4 is, who PW6 is, what is MO5. So this appendix is actually a very integral part of the judgment. So the rules also state, our rules also state that a judgment should contain the points for determination, the decision, and the reasons for the decision. Then, in the judgment, the accused witnesses, exhibits, and material objects, like Madam has already stated, shall be referred to by their nomenclature or number and not just by their names. In the event there arises a need to refer to the accused or witnesses by their names, the number shall be indicated within brackets. So another important thing is judgment should be in paragraphs, and each paragraph is to be numbered. The presiding officers have the discretion to organize the judgments into different sections, like Madam has already elaborated, like headings and subheadings. But most importantly, all judgments should have the case number, the cause title, as already informed by Ms. Samyan, on top of every page of the judgment. Now we come to the contents of a judgment. So I think it's already been elaborated before. We have the introduction, the body, and the conclusion. So introduction, we need to briefly state the facts of a case. Like in a criminal case, since I am dealing with criminal cases, judgments of criminal cases, the particulars such as lodging of the complaint, action taken during investigation which is incriminating against the accused, like collection of blood sample, seizure of material objects, those should be mentioned. Then the findings of investigation. Then the allegation that has been made out against each of the accused or one accused. Then after that, in brief, we write about the framing of charges. So what charges have been framed against the accused? What is he actually facing trial for? Then the examination of the prosecution or the complainant's witnesses. Then the accused under section 313 and defense evidence, if at all. Then we come to the body. The body will contain again the points for determination. Here we appreciate the facts, the evidence, the applicability of law, and whether the ingredients of the offense have been fulfilled. Then towards the end, we will come to the conclusion, which will include the decision. And if there is a conviction or an acquittal, we have to specifically state. Here again, I would like to refer to the Sikkim Criminal Rules of Practice of 2021, which states that in case of conviction, the judgment shall separately indicate the offense involved and the sentence awarded. In the event there are multiple accused, each of them shall be dealt with separately. In case of acquittal, and if the accused is under detention, a direction shall be issued to set the accused at liberty unless required in any other case. So these are, I think, the essential things that needs to be mentioned in every judgment in a criminal case. So then, contents of a judgment, the Honorable Supreme Court has stated in Som Mittal versus Government of Karnataka that courts should only deal with the subject matter of the case and the issues involved therein. In Aftab Ahmed Khan versus State of Hyderabad, it is observed that the obvious duty of the court is to give a summary of the evidence of the material witnesses and to appraise the evidence. And then we have to see whether the reason behind this is to arrive at the conclusion as to whether the testimony of the witnesses should be believed or not. We also have to, when we are dealing with the evidence of testimony of a witness, it is very important for us to also look at the cross-examination to see if the witness has withstood the test of cross-examination or not. Then another important aspect when we're dealing with, again, criminal cases is that the name of the victim is not to be disclosed in a judgment, especially in cases involving sexual offences. The name of the victim should not at all be disclosed. This has been reiterated in S. Ramakrishna versus State, represented by the Public Prosecutor, High Court of Andhra Pradesh, Hyderabad. So here it has stated that keeping in view the social object of preventing social victimization or ostracism of the victim of a sexual offense, for which Section 228A has been enacted, it would be appropriate that in judgments, be it of this court, higher court or lower court, the name of the victim should not be indicated. So now we come to the next topic, that is marshalling of facts. So here I would like to again draw, while discussing this issue, I would like to refer to the judgment of the Honorable Supreme Court in State of Andhra Pradesh versus Gautu Ramhunaya. I'm sorry, I'm not being able to pronounce it right. So here the judgment of the trial court judgment was set aside. It was a case of murder, and the Honorable Supreme Court has held that the learned judge has not at all considered and marshaled the evidence examined on behalf of the prosecution. So a gruesome murder had taken place, and the evidence of eyewitnesses were not at all taken into consideration by the learned judge. So it has, the points of determination were not formulated, and the presiding officer also did not marshal the evidence on record. So resultantly, the learned judge, it was opined that the learned judge did not come to a specific finding on each of the points for determination by recording specific reasons for arriving at such decision. Then another case, Mukhtar Singh and others versus State of Punjab, which I have referred to, I think, on numerous occasions in my presentation. This is a judgment of the Honorable Supreme Court delivered in 1995. It has been held that the trial court should have reproduced and discussed at least the essential parts of the evidence of the witnesses, besides recording the submissions at the bar. So this is to enable the appellate court to know the basis on which the decision is based. Like Madam stated already, it's not just, we should not just reproduce what has been stated by the witnesses, but we should see how we have applied our mind and how did we come to a certain decision. Then here I would also like to draw our attention to section 58 of the Indian Evidence Act. While we are marshalling facts, the facts that have already been admitted need not be proved, because then we would be saving our time, making it concise. Our judgment will be more concise. So to conclude, while writing judgments, it is pertinent to discuss the evidence of witnesses and marshal the facts while arriving at a decision. Now the next topic is charge drafting. There was a lot of discussion on this, so I hope my presentation will not be very repetitive to what has already been discussed, so I'll just briefly run through it. The Honorable Supreme, not the Honorable Supreme Court, but in Asaram Bhavadin Yadav was the state of Maharashtra. It has been laid down that the statutory prerequisites can neither be watered down nor bypassed, because any defect in the charge would have serious repercussions on the validity of the trial. So in this judgment, section 216 has been stressed upon, where the court has the discretion to alter or add any charges, and after that, the procedure as laid down in section 217 of the CRPC shall be followed by recalling the witnesses. So I think the fundamental principle of criminal jurisprudence is that charge as framed must be proved. So the consequence of non-framing of a charge, which I think Lordship was raising the query earlier. So the consequence of it is that it will seriously prejudice the accused, because he was neither afforded an opportunity to explain the circumstances as he could have done, nor was he able to put forward an adequate defense to that effect. So the Honorable Court has laid down that there was a failure of justice, and consequently the conviction in respect of this set of facts have to be quashed. Then the Honorable Supreme Court has laid down in Kantilal Chandulal Mehta versus State of Maharashtra and another, this was delivered in 1970, that there was failure of justice due to the omission to frame a charge against the accused, and consequently the trial should be recommenced from that stage. In Narendra Singh and another versus and others versus State of Punjab, mention of the section in the judgment is not the requirement of law to convict a person. This was a case where section 34 was not mentioned, but the offence was found to have been done in furtherance of common intention. Now coming to the next topic, appreciation of evidence, factual findings and analysis. While referring to the observation made in State of Uttar Pradesh versus Jageshwar and others, AIR 1983 SC 349, each piece of evidence must be considered and assessed on its own merits and then accepted or rejected. So, and then again, Mukhtar Singh, it has been held that the trial court was expected to notice and scrutinize the evidence, and after considering the submissions raised at the bar, arrive at appropriate findings. So again, it's reiterated in the later part of the judgment that the trial court was to notice, consider and discuss, howsoever briefly, the evidence of various witnesses as well as the arguments addressed at the bar. The trial court failed to do so, and it has even, the Honorable Supreme Court has even noted that the trial court has failed in the discharge of its essential duties. So I think the essential duty of a court is to notice, consider, while writing a judgment, we have to take into consideration the evidence, appreciate it, and then the factual findings, and then be able to properly analyze it. Coming to the topic, logic of adequate reasoning. So again, I'm referring to Mukhtar Singh. The Honorable Supreme Court has defined that a decision does not merely mean the conclusion. It embraces within its fold the reasons which form the basis for arriving at the conclusion. Then in State of Punjab versus Jagir Singh and others, it has been laid down that in arriving at the conclusion about the guilt of the accused charged with the commission of a crime, the court has to judge the evidence by the yardstick of probabilities, its intrinsic worth, and the animus of witnesses. Every case in the final analysis would have to depend upon its own facts. I think Ms. Zameng had already talked about it, the animus of witnesses. So here, this has been referred to. Then, when we are talking about judgments in criminal cases, another principle that needs to be borne in mind by the honorable judges, by the learned judges, is that the principle of benefit of doubt. In a criminal trial, the jurisprudence is that the case of the prosecution or the complainant has to be proved beyond reasonable doubt. And if any doubt arises, benefit of the same must go in favor of the accused. So in Abdul Ghani and others versus State of MP, it has been laid down that the story given by the eyewitnesses has to be carefully scrutinized, and unless it can be said with reasonable certainty that a certain person took part in the riot, the benefit of doubt has to be given to the accused. Then, I think with this we come to the reasoning arriving at a decision. So last but not the least, in a criminal trial, sentencing also forms part of the judgment. So Rama Naram versus Ramesh Naram, it has been laid down that a judgment is not complete unless the punishment to which the accused person is sentenced is set out therein. So now, how should sentence be awarded? Coming to the next topic. Here the Supreme Court has observed that undue sympathy towards the accused by imposition of inadequate sentence would actually do more harm to the justice system, as it would undermine the confidence of the society in the efficacy of law, and society could not long endure under such serious threats. So it is the duty of the court to ensure that proper sentence is awarded, having regard to the nature and manner of execution or commission of the offense. So a liberal attitude by imposing legal sentences or taking too sympathetic a view is against societal interest. The court will be failing in its duty if appropriate punishment is not awarded for a crime. In State of MP versus Sheikh Shahid, it has been laid down that the yardstick of determining sentence is the nature and gravity of the offense, and has cautioned against placing reliance upon reasons such as accused being from a rural background or length of time. In Jamil versus State of UP, it has been stated that punishment must be appropriate and proportional to the gravity of the offense committed. So there are numerous judgments of the Honorable Supreme Court which talks about sentencing. Sailesh. Then another one is again the Honorable, this was given in 2012. Just punishment is the collective cry of the society. To protect the society, and such sentence should be imposed which will reflect the conscience of the society, and the sentencing process has to be stern where it should be. To end my presentation, I would like to quote Justice Bhagwati in Santa Singh versus State of Punjab. This is again with terms of the concept of proper sentencing. He has been pleased to state that a proper sentence is the amalgam of many factors such as the nature of the offence, the circumstances, extenuating or aggravating of the offence, the prior criminal record, if any, of the offender, the age of the offender, the record of the offender as to employment, the background of the offender with reference to education, home, sobriety, and social adjustment, the emotional and mental condition of the offender, the prospects for the rehabilitation of the offender, the possibility of the return of the offender to a normal life in the community, the possibility of treatment or training of the offender, the possibility that the sentence may serve as a deterrent to crime by the offender or by others, and the current community need, if any, for such deterrent in respect to the particular type of offence. These are factors which have to be taken into account by the court in deciding upon the appropriate sentence, and therefore the legislature felt that, for this purpose, a separate stage should be provided after conviction when the court can hear the accused in regard to those factors, bearing on sentence, and then pass proper sentence on the accused. So thank you.
Otherwise, it's a little difficult standing there and not being able to follow what is on the screen. The last presentation to Hon'ble, with the permission of the Chair, Honorable Mr. Justice Bhaskar Pradhan. I'd like to begin my presentation. Perhaps we have dealt with writing of judgments in the trial cases. Perhaps this is one area that we normally do as district and session judges also, to write judgments in appeal. And my presentation will be on the criminal cases. Can you give me this? Much time, I'll come to my presentation. While writing an appeal judgment, normally these are the points that we require to consider. Number one is the point for determination, the decision thereon. Like all of you have already said, the reasons for the decision, and if we reverse the judgment or vary, what are the reliefs that we require to give. Section 354 and 387, if you see, 387 will deal with judgments in appeal. The body of the judgments will not be as very different from that we write in the trial court judgment. We normally begin with an introduction of how to, and it should begin with a short sentence. And before I go further with the presentation, I will acknowledge the fact that I've relied heavily on S.D. Singh's book on writing judgments, and my presentation is mainly based on that particular book. We begin with a presentation of writing in short what the reader is going to read about the nature of the case, perhaps in one sentence that we begin. And then we give the facts to be summarized into 4 heads. Number 1 is, what is the prosecution's case? After we finish that, then we are required to mention what is the case of the accused, the findings of the trial court, and then the finding of either the facts or the law that is under challenge. These are the 4 facts all the appeal judgments should have. The facts are to be narrated in such sufficient manner, and it has to be complete. And so complete sometimes that you don't need to refer, or the further appellate court don't need to refer to the trial court judgment to read your particular judgment, and it will not be a continuation of the judgment of the trial court. It should be separate with its own body and facts. The points for determination to be set forth in a manner that in a first glance anybody will know that nothing material has been omitted, everything has been included. The body of the judgment, there comes. We discuss the evidence. Madam has already dealt with how the evidence is to be discussed, the questions of fact as well as law involved. The reasons for the finding. Without unnecessary writing an elaborate judgment, brief give clearly what are the objections urged and how are you disposing of. This was in this particular case as well. You have to give your reasons for the finding. We must examine the evidence and the points urged by the appellant. You have to decide. Thereafter, the discussion and analysis of the evidence. You have to analyze the evidence, the objections taken, what are the challenges that were made, and then you give your own findings on this. Just an example, that in one particular case, this is a case of a very old case, and this is not the present CRPC, but the old CRPC. This was the one sentence order that the appellate court had passed. Just said that, heard the appellant, I do not think it necessary to direct prosecution, appeal dismissed. But it was held that this is not a judgment at all. A retrial was ordered. But what I'm trying to say is, don't be so brief that we don't discuss the basic structure or the basic rule of writing a judgment. And even in this case, it just says that I've gone through the records and the conviction is sound. This is also no judgment at all. It has to be self-contained, like I already said. So self-contained that findings of facts may be sustained on bare perusal. The court should reproduce material evidence. The word material has been highlighted several times today. And also state the reasons for holding, whether it is proved or not proved or disproved. It is not enough to say that certain facts was proved or that evidence was unnecessary. And this is a particular case, Nagpur, a very old case, where it has been mentioned also that the judgment or an order must be clear and bear the intelligent appreciation of the facts on the part of the appellate court, the necessary facts and materials that would warrant even the High Court, the Hon'ble High Court, to infer that all the essential things were considered by the appellate court in the district level. Now, it so happens that at times, and many a times, there are more than one accused. So it is important that the case of each of the accused is also to be taken into consideration, discussed, and decided. Finally, we come to the granting of the relief. Now, the last part of the judgment in an appeal is the operative portion. Whether it is allowed, dismissed, this has to be done, or whether it is modified. All right? This is also, I think, quite an important part so far as the appellate courts are concerned, because at times there are cases which are remanded back for retrial. Now, sometimes it so happens that you'll see a number of judgments of the appellate court that it will give its own reasons for remanding it back. Then one-line word will be, my observations will not be affecting the merits of the case. It is undesirable for the appellate courts to express its opinion and then remand the case file back to the trial court, because it so happens that the trial court will be induced or affected by the reasoning of the appellate court, and these kind of, I think, observations should not be made. In these type of cases, this is my experience, I hope, and I think all of you have experienced the same. The trial court will feel embarrassed in coming to an independent finding on such questions which has already been decided by the appellate court, and the cases remanded back. Now the final thing is, what we see is the criticism. Now I'm talking about as the appellate court in the district level. When we write our judgments, and when the trial courts also write the judgments, we don't criticize on the witnesses or the nature of the case or even the advocates. Similar is the case when it comes to us, we should not criticize the judgment of the trial court. And this is one particular case. Abdul Aziz, I think Ms. Mahima has also relied on this. The use of criticism and imputations, this affects the trial court judges. And finally, with these words, I'd like to end my presentation, that judgment is not the place where you place strictures and it does not add weight to the judgment. So with these words, thank you for giving me a patient hearing, and I wish you all a very good day and a lovely weekend. Thank you.
Hello. Yes, Lordship, that was the last presentation, so the House is open for interaction. Please, if any.
About the second session is, although all of you are afraid that you would be repeating what the earlier speakers would have spoken about, what was the takeaway from the second set of speakers was the vast experience that you brought along in your presentation, which was missing in the first session because of lack of experience, nothing else. So that, I think, gave us a very close and a closer insight into the working of the trial court, which would not be possible if you all did not speak repeatedly on the same issue, but with your experience, making sure that you're not repetitive and adding more to the session. I think there was a conscious effort on each of the second set of speakers to avoid repetition but add something more. And in that process, I think there was a lot of take home for all of us. I gained a lot, and I'm sure the other ones would vouch that is correct. I gained a lot. There's so many things I wouldn't know about, or which may have just slipped out of my mind, which you have presented before us. So this kind of interactions, I think, would be very, very relevant, very, very important for all of us. And it gives us, there are so many diverse views on writing judgments, but there is a commonality which ran through the entire thing, and that is something which all of us can take home. We can have our own style of writing judgment. One can be Justice Krishna Iyer, another can be Denny. And then you can be your own. But I think what should not get from the path is that we are doing justice for the people and we are writing judgment which will affect the parties. That's very, very important. Once we know that, then I don't think that we can go astray. Anything that you want to discuss? I have nothing further to add to this beautiful session.
I think we'd all like to thank your Lordship for sharing your weekend with us despite not feeling well, and I think all of us have many, many takeaways from this session. So thank you to your Lordship and to the Director, SJ.
Okay. Before we part, this is a request to the Director. This presentation by PPT by each of the participants must be the property of the Judicial Academy. It should be signed and kept by them, by the Judicial Academy, and maintained properly. I think a fantastic presentation. Each of the participants can work on this, and if you want it at one point or better it, and you can just recreating this so that we have a database of information which is, I think, vital for our growth.
Yes, sir.
So please do that.
Yes.
I think thank you so much and fantastic work out of, and have a lovely weekend.